They have to log in. They have to log in to the laptop. So we're waiting.
Okay.
Oh, sorry.
Are you ready? Great. Okay, let's get on the record, please. It is Thursday, the 28th of September. And we are ready to resume with State versus Kamdem, 22 SC 183536. We have Mr. Kamdem here. Good morning, sir.
Good morning, Your Honor.
We're working on getting the headphones powered back up. We've requested IT to come to log in. You don't need to put them on yet because, oh, they are working?
He just.
He just did it.
Oh, you logged them in?
No.
Oh, there he is. Oh, the stealth IT expert. Thank you, sir. We're good. All right, pop those things on. Please put your headphones on. Great. Are they working? Two thumbs up from Mr. Kamdem. Good. We have our prosecutors here. We've got our defense attorneys here. And on our screen, we've got our draft jury charge. It is time for the charge conference. And the way I like to do this, as some of you have experienced, is I'm going to flip through until I get to a highlighted area, because that's where I've got a question, need some input, have a concern. If I skip over a space where you've got a concern, say, wait, we need to go back to identification, which is not in here, and we can talk about it. And then when we're done, I'll see if there's anything else that either side wants to add or subtract. So without further ado, I edited Graves' suspicion. I think I don't know that it's appropriate. There is some case law that says it's not a mandatory one, but there's also case law that says omit it at your peril, judge. So it's a correct statement of the law. I don't think the sentence that I've struck through is necessary. I think we can tell the jury grave suspicion is not sufficient, but I don't think we're in speculation territory. Ms. Feely, any objection to that revision?
No, Your Honor.
Ms. Hall?
No, Your Honor.
All right. As of last night, defendant's choice not to testify was still in there. I didn't think of that until this morning, but Mr. Kamdem did testify, so I will not include the paragraph about a defendant not testifying. I think we should eliminate good character of the defendant. No witnesses came in to say he's a great guy as classic character witnesses. I know Ms. Feely very creatively got in indirectly some circumstantial character evidence. Who would hire someone who was a sexual predator? No one. But I don't think that requires or triggers the good character of defendant charge. Ms. Feely, do you agree?
I do.
Ms. Hall?
Yes, Your Honor.
I will omit it. We did have testimony from a DNA expert, but there was, for all sorts of understandable reasons, no DNA match. So I don't think we need to give this. This is the pattern charge. I don't think it's particularly helpful in the grand scheme of things anyway. But in this case, when there was no identification made, I don't think the jurors ought to be weighing the credibility and accuracy of the science involved, et cetera. I don't get the sense the state's going to say, actually, they did bad science and there should have been an identification. The argument's going to be, hey, because the man house people didn't call for 3 days, there was no evidence left. Do you have any objection, Ms. Feely, to omitting the DNA charge?
Yeah.
Ms. Hall?
Yeah.
You guys are very flexible today. Presumptions and inferences. It is what the charge says. I don't know that this case really needs it. It's not a, well, something happened in this area and a natural effect of that was something happened somewhere else. And I prefer to keep the charge as streamlined as possible. So I didn't see a compelling need for it. Ms. Hall, do you want to make an argument for including it? Okay, Ms. Feely?
No.
I will remove it. So, improper sexual contact by an employee. There is no pattern charge for that. This is the charge that in the indictment, the code reference is to improper contact in the first degree. That's 5.1B, 16.6, 5.1B Bravo. But the language that is used, in particular, unlawfully engage in sexual conduct as opposed to sexually explicit conduct, is actually subsection C. And the language that you see on the screen now is my distillation of that statutory language into the format we're trying to use more and more with the offense charges that break it down into discrete elements that are numbered. So hopefully you all have given it a read. I think statutorily it's correct. The fuzziness around it is that my guess is the state intended to charge the felony version, which is B, but they didn't include the language of the felony version. And so what they have charged is actually a misdemeanor. I'm not talking to the jury about felony versus misdemeanor. But that was the hiccup that I sent an email about yesterday or the day before, that if people were struggling with, do we go with the statutory citation, B, or the statutory language that was employed, C? I read the case law pretty clearly as saying you go with the language rather than the citation. And I think Ms. Feely echoed that. I think she ought to echo it given misdemeanor versus felony. But I think it's what the law says. That was a lot of talking. Ms. Hall, do you have any concerns about the language of the charge that I've included there? And do you want to push back at all on the notion that I ought to charge the jury on subsection C rather than subsection B?
No, Your Honor.
Okay. I know you didn't write the indictment. You inherited it. Here we are. Ms. Feely, do you have any issues or concerns with what I just discussed?
No.
All right. I will take the highlighting off that. It's good to go. Abuse of an elder person. Also, no pattern charge. So this was pulled, this is sort of my distillation from what the statute says. And here the correct statute was cited and the language quoted from it. Ms. Hall, anything you want to edit with the abuse of an elder person charge?
No, Your Honor.
Ms. Feely?
No, Your Honor.
All right. Oops. Aggravated assault with intent to rape. I think Ms. Niles told me that this came from the defense, maybe as a lesser included. This is the language for it. I'm just sort of confused by it. And it's always complicated when we add lesser includeds, but if they are justified by the facts and the evidence, we should include them. It just seemed inconsistent with the defense of, no, at most I was seated on the bed trying to mess with this handrail. So I don't know who submitted it. Whoever did, talk to me about why it should be in.
If it was us, we'd withdraw it.
Okay, Ms. Hall, any objection to removing aggravated assault with intent to rape? Okay. That was it. That's what I had. So we'll go back to the beginning. Ms. Hall, did you have any other edits you wanted to make to the proposed charge? Okay, Ms. Feely?
No.
Dang, we're ready. Will you guys get some bonus time to get ready for closings? Ms. Hall, will the state be opening and closing or just having the last word?
We'll be opening and closing.
Okay. I think each side gets an hour. I don't think this is a 2-hour case because it's attempt. So I'll be keeping track of the time. I don't think either side should have trouble fitting everything in within the hour, but 1 hour for each side. My thought would be as soon as we have all 14 jurors, we'll start. I know I told them 9:30, but if we get everyone at 9:20, let's go ahead and do it. Ms. Hall, anything else we need to talk about?
Nothing from the state.
Okay, are you going to be, I guess I can take this down, doing a direct feed in for your PowerPoint, or are you going to run through Zoom? How do you want that to work?
We're gonna do a direct feed.
Okay.
And then share the Zoom like we did yesterday.
However you want to do it, just test it before they come in multiple times. And then Ms. Feely, if you're going to use a PowerPoint, just coordinate, maybe you will want to test yours to see if you can use their direct feed or if you'll be running through Zoom rooms, but let's use this time to see how all that works. Ms. Feely, did you have anything else before we pause for the jurors to get here?
No, Your Honor. I'm working on sharing screen now.
Great. Okay. What's on that one? Oh, it was off. How does it go off? I wonder. It just, okay. It's good.
So I think it's this thing right here.
What is this? Which one?
Next to the minus.
One?
Yeah.
Okay.
Do you need to use the restroom? Do you need the restroom?
No, thank you.
It's gonna be a couple hours.
I'll be okay.
Where are we at? 10. That's not enough, but they're not late.
Thank you so very much.
All right, Deputy Gordon, if you would, before you go check, it sounds like they have more people like, hey, great to see you. Get this to Ms. Hall, and then Ms. Hall, if you get it to Ms. Feely, proposed verdict form. When I come back, just let me know if there are any issues.
Thank you.
Do you want me to flip the PowerPoint for you, or are you gonna do
I can
it?
do it. Thank you. I've got a clicker.
Where's the verdict form? I'll trade you. If you bring me that. You'll give one of these to the state. Thank you. We're supposedly missing 3 jurors. Hopefully they're coming soon. Now down to one. Who is it? Okay. You let him in your office? For your office? So anyone can get in there? Did you talk with Michelle? Because she's the one who is good at pushing Dream. Well, but maybe she needs to bug him again. Well, it's because they're messing with it. They're trying to do their PowerPoint.
I'm never gonna live this down.
You know, it's those first impressions and they stick like, don't let her touch the equipment.
Oh my gosh. It's just done, it's been going down all the time, like one screen was just ready in a while.
Okay. Well, it seems to be linked. No one's doing anything wrong, but it seems to be linked when you guys do the, hey, I want to talk to that directly, and then we cycle back. It has some hiccup. So is there nothing on it now? Oh, there's that picture. Okay. It's so big. Hey, is Deputy Gordon, do you know how to, did you ever make this work, or we need to call IT? Okay. What's on the big one? The correct stuff? Okay.
It's just not hooked to the Zoom.
Okay. Which is okay, because I think all we'll be doing is, can you see if your direct connect works now? Do we need to get you glasses? You're all squinty.
Yeah, see.
Is it good? I can't see because, of course, where I sit. That's all right. When Judge Ingram was in here doing that trial, she complained bitterly about the set. I'm like, hey, it's not your courtroom. But I in fact, cannot see what's in there. But it's working. All right. And Ms. Feely, how were you doing? Were you doing direct connect, or you were doing it through Zoom?
I was doing it through Zoom.
Okay. So we'll need to get them to come fix it, but it would really be after the first part of the state's closing. We're still waiting on. Okay. What's the, oh, she just got here? Oh, He was just in there. Excellent.
Just when you said.
All right, thank you. Uh-oh. Are they, you're waiting on me? Oh, okay. I thought they were getting situated. Okay.
Yeah, Ms. Rivers,
Oh,
she's grabbing a bottle.
that's right. She was feeling a cough. Come on.
Judge, which monitor is not working?
So it's the big one again, but when Aaron gets here, we just need to chat. It keeps disconnecting when the state, to do its closing, wants to connect directly. So they do some input change. And when we go back with the input change, it loses the Zoom link. If all I need to do is re-add it, that's great. I just don't know that. Oh, hold on one second. I'll talk to you in 1 second. Let me see if I can just re-add it, in which case we're good to go. The gallery.
Okay. He says he's headed this way, Judge.
Okay. Yeah, it's not letting me talk to it. Thank you. It's creepy that she's actually not in Georgia. That's pretty impressive. Okay. Ms. Rivers, are you ready? Okay, we're back on the record. All our jurors are here, and it's 9:32, so we should get going. Ms. Hall, are you ready for the jurors?
The state's ready for jury.
Okay, and I think where we left it is that we'll start with closings. I'll explain that the state gets to open and close because it has the burden of proof, et cetera, but then we'll flow directly into your closing, the first part of your closing. Is that your understanding of where we are, Ms. Feely?
Yes.
Great. Jurors, please. Have you all had any discussions about which exhibits go out with the jury and which don't? Okay, at our next break, let's have you do that,
I don't
please.
expect that to be very contentious.
No, I don't either, but better to not have the jurors waiting for the exhibits.
All right, Missouri. All jurors are present in the county court.
Thank you, Deputy Gordon. Everyone else can be seated. Mr. Dorsey, hold on 1 second. Let me just welcome our jurors. Good morning. Thank you for being here on time and ready to go. We are as well. Let me have a brief IT discussion. Here is my diagnosis or observation. When one of the sides creates a direct connection to that large screen, we call it the gallery screen. When they're done and they say, using the input selector, we're all set, that device is kicked out or removes itself from the Zoom rooms, and I can't go in through my Zoom account and reactivate it. It says it can't find it or it won't connect. So something about switching it to a direct feed from a laptop that's not part of the Zoom session breaks that connection and we can't get back in. And that is an issue because the way to avoid any lag in playing videos, et cetera, or to minimize it is to connect directly. The state's about to give its closing. They're going to have a direct connection. When they are done, the defense is likely going to give a closing. And I've been told that they will run their PowerPoint through Zoom rooms and this thing won't be in it. And I don't know how to get it back in. Was that any of that make sense? You're like, Judge.
Makes sense. I don't believe the disconnecting is affecting it.
Okay.
It is saying here something with the connecting to the network. I think it might have just happened at the same time.
Okay.
But I don't believe that the disconnect. But I can sit in and watch it.
Great. As long as you'll fix it, then and better yet, figure out why this happened. This has happened several times during the trial, which is why I was just linking the state has done the direct connection, and when they're done, we seem to be floating around, but it may be a different, just a coincidence. All right, ladies and gentlemen, thanks for your patience. Last night, if you recall, both sides rested, so the evidence is closed. There are 2 steps left before you begin your deliberations. Number 1 is closing arguments. The state, because it has the burden of proof, gets to open and close, if you will. So Ms. Hall or Ms. Marsh is going to get up in a moment and share with you some thoughts about what the evidence has shown and what you ought to do as jurors, and then sit down. Ms. Feely or Ms. Pinto will then have an opportunity to give a closing as well. When the defense attorney is done, the state gets to say a little bit more. They have the right to have that last word because the burden's on them to convince you beyond a reasonable doubt that Mr. Kamdem committed one or more of the crimes that are charged in this indictment that you'll have during your deliberations. So that's what you'll see and hear. 2 presentations from the state that sandwich the defense presentation. When they're done, we'll probably take our morning break, and then I will read to you this charge. This is the jury charge that we worked through this morning after several iterations were circulated with the lawyers and with me. Once I've completed the charge, you then retire to the jury room, and I don't say for the first time, don't talk about the case. I say the reverse, talk about the case. Now you deliberate and you decide if the state has met its burden. Okay? So with that, ignore the man working on the monitor. Ms. Hall, when you're ready. Or Ms. Marsh, I didn't mean to single anyone out. But you don't have to do it if you can't use that screen. We let Mr. Dorsey do what he needs to do. Is it good? Is it not good?
I still, you have to wait until.
Yeah, if that's okay. She's going to start her closing with the direct connection.
Okay.
You can connect it, guys.
Did he break it?
Broken trust. At the beginning of this trial, we stood before you and told you that that's what this case is about. How this defendant broke the trust of Ms. Flora Robinson and her family. We have presented evidence throughout this trial to show you how that has occurred. And now comes the time when we put it all together for you and package it up in a nice bow so that you can take that information back and make your decision. But before we tie everything up and make it flow and make sense, I do want to go over a couple of things with you. First, I want to remind you of your duty in this case. As a juror, We talked to you in jury selection about being a fair and impartial juror. Your job today, and as it has been throughout the duration of this trial, is to honestly seek the truth. The truth is what matters. You are not to seek doubt. So there are a couple of things you can consider when you're seeking the truth. You can think about the statements that you heard when the witnesses got up here and told you what occurred. You can think about the expert testimony. You can think about the videos, the documents. Who has a motivation to lie in all of this? The elements of the crime, which I'll talk to you about a little bit, and also the judge will give you that information as well. And then you can use your common sense. When we were speaking to you about being a fair and impartial juror and setting certain things aside at the beginning, that did not mean to leave your common sense at the door. You come in with your own experiences and you use those things to make your decision. Now, there are several things that you are also not to consider. You're not to consider passion, public opinion, how you feel about the police, the man house, or whoever else. Not the public feeling, sympathy for the defendant, any prejudice, if you disagree with the law, punishment, penalty, none of those are in your consideration as a juror. Just those things that I've mentioned. You are to apply the facts and the evidence which came out through this trial to the law that the judge provides, and you're to come to a conclusion based off of that information. Now, let's talk about a couple of legal principles. The law will come from the bench. That's what the judge was talking about reading you the charges. But there are just a couple of things that I did want to break down for you. The burden of proof. This has been thrown around throughout this trial. The state has the burden of proof, and that is a burden that we accept to prove every essential element of the crime beyond a reasonable doubt. Reasonable doubt. I'm sure you all have heard that before, but what does that mean? Reasonable doubt means exactly what it says, reasonable. It's based upon common sense and reason. It's not vague or arbitrary. It's not anything that has to be to a mathematical certainty. You don't have to say, I 99.9% believe this. It's a doubt for which you can say, I don't believe this because insert reasonable conclusion. Unreasonable doubt would be non-existent or unpresented evidence. Conjecture, you can't just make the assumption because something is missing. Speculation. But as I said, common sense reason, not an arbitrary doubt, is a doubt for which a reason can be given. So if you're like me, you may be a little visual. So answer this question to yourselves. What is this a picture of? I'm sure everyone said, well, that's a dollar bill, right? Now, perhaps I wish I had Jefferson's hair, Washington's hair in there. Perhaps I wish I had the rest of the seal, but even without those missing pieces, I know that's a dollar bill. That is what beyond a reasonable doubt is. The judge will also instruct you and has instructed you about the presumption of innocence. The legal presumption is what the defendant has, is a presumption of innocence until the state proves that guilt beyond a reasonable doubt. Now, what does that mean? At the beginning of this trial, when we were questioning you and talking to you about how the process works and selecting you to sit on this jury, he had the presumption then, before all of the evidence came in, before you saw the testimony of witnesses. At this point, as he sits before you, he does not carry that presumption of innocence because we've proven his guilt. So that is how that works. You don't have to, as you sit here today, you don't have to give him that presumption because you heard testimony and evidence to the contrary of that. We have proven this to you by using evidence. And there are a couple of different types of evidence. So you have direct evidence, and you have circumstantial evidence. They weigh the same. And making your decision, you can use all direct evidence or you can use all circumstantial evidence. There's no legal difference as far as weight. So direct evidence is, I usually say the senses. So I see this TV, that's direct evidence. You hear me talking, that's direct evidence, right? Circumstantial evidence, so that would include also, in addition to what you see and what you hear, that includes the videos maybe that you saw. That also includes the documents that were admitted into evidence. That is what we consider as direct evidence. Circumstantial evidence is when a person uses direct evidence to infer other facts, reasonable and justified in light of your life experiences. So I like to use the weather as an example. If I am outside driving in my car and it starts to rain, I see the rain, I hear the rain, that is direct evidence that it has rained. Circumstantial evidence of that would be, okay, perhaps you have been in this jury room all day, right? There's no windows in here. But before you came in, you read a weather report that said it was a 70% chance of rain. When you came in, it was dry, nothing had occurred. But when you leave out this evening, you notice that, well, it's cloudy now, and the pavement is wet, and I have raindrops on my car. Did you see the rain? Did you hear the rain? Well, no, you've been here all day. But you can use all of the information to conclude, okay, well, I guess it must have rained today. That is how you use those two different types of evidence. So let's compare that to this case. In this case, some of the direct evidence that you heard was Sheena testifying to what she saw. She walked into a room and saw with her own eyes the defendant on top of Miss Flora with his pants down, his butt exposed, thrusting, while Miss Flora's diaper was open. She saw that with her own eyes. Circumstantial evidence will be the video of him juggling with his pants and his belt. So he goes into an area, his clothing is one way. He comes out of the area, he's fumbling with his clothes, he's fumbling with the belt. His clothes look different than they did before. You can reasonably conclude that, well, something happened with his pants and his belt. He took them off, he had to do something. Why is he adjusting it? You can conclude, based on circumstantial evidence, that he removed his pants. You can take into consideration also the expert witnesses. So you've heard from a couple of different types of witnesses. One of the main experts that you talked to was the same nurse. And she was able to talk to you about certain things regarding her examination and perhaps why there wouldn't be anything different on Ms. Robinson. She talked to you about the condition of how Ms. Robinson was having vaginal itching. You can use that in your determination to consider whether something happened and what the defendant did when he was on top of Ms. Robinson. And the judge will also explain to you a very, very important concept. It's called the single witness rule. What that means is the testimony of a single witness, one person, if believed, is sufficient to establish a fact. There's a reason that this rule is in place, especially in cases like this. A lot of times when it comes to sexual offenses, people don't do this in broad daylight. This isn't a public offense. There's rarely any witnesses. We were lucky in this case that Sheena walked in on him. But because Sheena walked in on him and saw what she saw, you can believe everything that she said, and that is enough to convict the defendant. If it's not Sheena for you, it can be Ms. Jefferson for you. It could be Officer Tennessee for you. It could be whatever witness. But their testimony is, if believed, is sufficient to establish a fact. Now let's talk about the particular crime charged in this case. The defendant is charged with 3 crimes. Count 1, criminal attempt to commit a rape. Count 2, improper sexual contact by an employee. And count 3, abuse of an elder person. I'm going to briefly go through each of these for you to explain to you a little bit more about what they mean. So criminal attempt to commit rape, we're going to break that down a little bit because in order to do a criminal attempt, you have to commit an act that constitutes a substantial step toward the commission of a crime. In this particular case, toward the commission of rape. So a step toward getting ready to rape. What does rape mean then? We have to define rape. Rape is the carnal knowledge of a female forcibly and against her will. That is rape. Carnal knowledge of a female forcibly and against her will. Well, what is carnal knowledge? Penis to vaginal sexual intercourse. When a penis is inserted into a vagina, no matter how slight, that is known as carnal knowledge legally. Female, Ms. Robinson, you can go ahead and check that off of your list. She's a female, you saw a picture of her. Forcibly could be a few different things. You can think of force, and that doesn't mean aggressive physical force. This is force. me just picking this up, I had to use some type of physical exertion to do that. So it doesn't have to be a shaking or beating or anything like that. Threats of harm or intimidation. And again, intimidation is one of those things for your interpretation too. It does not have to be making threats. It could be someone towering over someone while they're shrink down in a unprotected state. And then lastly, against her will, you heard from the doctor, she was in no space to consent to anything. She had dementia, she didn't even know what was going on. So we know that this was done against her will. Improper sexual contact by an employee. This occurs when an employee knowingly engages in sexual contact with a person with whom the employee knows or reasonably should know is admitted for care at the facility for which that person is employed. Several people came up here from the Mann house. The defendant worked for them. He knew Miss Flora was there. Everyone knew Miss Flora was a patient. He engaged in sexual contact with her. Well, how? Sexual contact is any contact involving the intimate parts of one person or of either person for the purpose of sexual gratification. And lastly, abuse of an elder person. That is count 3. That is when a person inflicts sexual abuse on an elder person. So an elder person just means a person is 65 years of age or older. You can go ahead and check that off your box. Ms. Robinson was 72 years old when this occurred, so that's an easy one. Sexual abuse is when a person supervising the welfare of an elder person forces that person to engage in certain conducts for the purposes of sexual gratification. And there are a couple of them that can be considered. Lewd exhibition of the genitals or pubic area of either person. Physical contact with either person's unclothed genitals, pubic area, or buttocks, or with the female's nude breast, or penetration of the vagina by any object, except when done as part of the medical nursing procedure. We know that when the defendant was in the bed with Ms. Robinson with his hands down, there was nothing medical about that. It was sexual contact. He was on top of her thrusting. So he did commit the offense of abuse of an elder person. Now, like I said, I wanted to give you a general overview so that you'll know what you need to be listening to and considering. In a moment, we're gonna get back up and tie it all together for you. And once we do that, we'll be asking you, and justice will be requiring that you find this defendant guilty of all other counts in this indictment.
Thank you, Ms. Marsh. So, Mr. Dorsey, now we need to see what happens with that screen. It went back to that great picture. See if I can add it. Okay. So it says it cannot connect to Zoom rooms. Hold on, I just mashed it enough. Now or you did something, but the 4th time it said, oh, now maybe we can connect.
It's working.
Okay, I won't press any buttons. All right, is it good? When you're ready, Ms. Feely, thanks for your patience with our technology.
Thank you, Your Honor. Horrible, stigmatizing, heinous accusations against a very vulnerable population. When you walked in here and heard those charges, you probably were like, where can I sign to put this man under the jail? It's hard to imagine anything more terrible. It's hard to imagine anything more terrible to be falsely accused of. Like I told you in opening, Mr. Kamdem has been waiting over 2 years for you, for a fair-minded, impartial jury to hear the evidence in this case. Not proven is not guilty. The state has the burden to prove every element in the indictment, which you will have a copy of. They said they accept this burden, but then promptly asked you not to seek doubt. That's what got us here, just rubber stamping all along the way when there really wasn't evidence. The state's witnesses didn't witness anything except for Sheena Edgerton, who is very problematic. I too, this is my only chance to address you, so I am also going to talk about the law in this portion. And reasonable doubt is so important. So you heard that there was a civil lawsuit in the house, as well it should have been. So that would be, the civil standard is lower. Then to get an arrest warrant, you need probable cause. They base that probable cause only on Ms. Edgerton, but that's there. But probable cause is not enough for a conviction, thankfully. There's several more steps to beyond a reasonable doubt, which is what the state must prove every element of this to you. And what is a settlement? A settlement is an agreement that ends a dispute, results in the voluntary dismissal of everything else. That suit was against the Mann House. That settlement decision was the Mann House's decision. You heard about how terribly this was handled by the Mann House. They didn't follow the law as mandated reporters. The first call should have been to 911, even if you're not a mandated reporter. If you see a violent rape, which is what she claimed, your first call is to 911. Your second call should be to Ms. Jefferson. The fact that she wasn't contacted for 3 days is unacceptable. Because if they had just called her first, she would have said, take her to the hospital, get an exam done. I want this man prosecuted. And then we wouldn't have been here because the evidence wouldn't have been there. They admitted their various shortcomings and settled. So where does that leave Mr. Kamdem? The lack of evidence, the destruction of evidence, was created by the Mann House. But it's a huge problem for Mr. Kamdem. You should be very frustrated, and I hope you are, at the lack of physical evidence in a rape case, an attempted rape case. And the destruction of the evidence by Ms. Edgerton herself. You cannot resolve your frustration with the lack of evidence against Mr. Kamdem. You just can't. They don't have the evidence, and that's frustrating one way or the other, but you can't hold it against the defense. He didn't destroy any evidence. There wouldn't have been any, we wouldn't be here. You cannot resolve your frustration with the lack of evidence against Mr. Kamdem. And you cannot let the state lessen their burden of proof because of it. So when you think about reasonable doubt, if you are back in the jury room, you guys are talking and you think maybe this Edgerton saw what she saw, that is a reasonable doubt. If you think probable cause, if you're back there thinking, you know what, she probably saw what she saw, what she told us she saw, and she wasn't mistaken or misunderstanding it, that is reasonable doubt. I don't think the evidence supports that, but if you think probably, that is reasonable doubt. State showed you a dollar bill with some pieces missing. Sure, you can tell it's a dollar bill. You can't tell if it's fake. You can't tell what the state is hiding with those missing pieces. A case with that many missing pieces is reasonable doubt. Whether it looks like a dollar bill, you can't tell for sure if it's fake, if it's what's being hidden. That is not proof beyond reasonable doubt. Missing evidence is reasonable doubt. Another thing that is not reasonable doubt is grave suspicion. The judge is going to charge you on this. Evidence that places a grave suspicion. If you're back there and you are gravely suspicious that something happened, that is not sufficient to authorize a conviction. Grave suspicion is not sufficient to authorize a conviction. Sheena Edgerton comes to work an hour late, coming from her siblings' party. She was out partying until past when she was supposed to be at work at 11. Obviously not thinking clearly, because based on her actions that night. You saw a video, and you can ask to re-see it, and I encourage you to, that shows her true reaction, not her telling you, this is how I reacted. I was so upset, I ran out of the room, I ran to get my phone, that I then didn't use call 911. And Christy Mann inaccurately described for you when you were watching it. She looked at her, she was distraught. You can watch that video 10 times, and you will not see someone who's distraught. You see her wandering around, and then she wanders down the hall, and when she comes back, she's not running, she's walking at the same pace she had been. She's not. So she lied about that. That is untrue, and it's proven by the video. So instead, she calls the business office manager, Keisha, who tells her not to mention it to anyone, and she calls the bodyguard, Mr. Bagley. That's it. Then she finally goes back to check on somebody who she claims she just saw being violently raped and cleans her up. She's a medical professional. But importantly, what she says is that there was a bowel movement there, consistent with what Mr. Kamdem saw when he walked in the room. Does it make sense that a 72 at the time-year-old man would attempt to have intercourse with somebody within that condition, with a bowel movement? He was cleaning her. That's the only thing that makes sense. Or he was going to. She also testified that the sheets themselves weren't soiled, so she didn't change them. So that could have been something that was tested that also was not. For male and female. So all the state's case is based on is this one witness, this one eyewitness. And you can't even turn on the TV or open a newspaper without hearing how unreliable eyewitness testimony is, and how they lead to wrongful conclusions, and juries coming to wrong conclusions. And here, the one eyewitness is not consistent, and the things we can verify are verified to be not what she told you. Running out of the room, being upset, being distraught. Not in that video, she wasn't. One of you asked this question actually, and this is states 3, I believe it's in states 3. This was on the very night, 12:30 a.m. on the day in question. Her description, no butt in the air, because the state needs for that to have happened. They need for him to have been moved for the contact portion. So that's what she said the night of. You guys may remember, this is defense exhibit 1, because the state had her testify butt in the air, because they need that as an element of some of this stuff. And they didn't want you to know she had been inconsistent about that. So I brought this document in as defense 1. It's from the 8th, the day that it finally was reported, this supposed horrible crime. And she doesn't mention it. Defense 2, again, another written statement, signed, this one's from the 10th, no mention of him being nude or her seeing his butt. Defense 1 and 2, because the state needs for you to believe that she was always consistent about that, because that is all they have. They needed you to believe she had her story out, but she didn't. Importantly, Ms. Edgerton told you that she got to work late, and she testified that she saw Mr. Kamdem and they talked for about 10 minutes. So the state makes it seem like she was always late, so Mr. Kamdem was just gonna prey upon this woman. But that is not true. He knew she was there because they talked. Ms. Edgerton told you that. When she arrived, they talked. So this wasn't a situation where she was late and he was taking advantage of her lateness. She was late, but when she got there, they talked. He knew she was there. You'll have a copy of the indictment, but count 1 requires the state to prove beyond a reasonable doubt exposed genitals of the accused. That is why they were so adamant that you believe she always said that. Count 2 also requires sexual contact. And count 3 requires sexual abuse. So they all need for you to believe that. Let's talk about, this is also in one of the state's exhibits. No history. He was 72 at the time. You saw on the body camera of Officer Kennedy that when he said, has he ever done anything like this before? There's like 6 or 7 people in that room and they're all like, oh no. We never. All of them jumped to say, this is not something that has happened with him before. And in one of the state's exhibits, I didn't want to bore you too much with repeating it, but 17 of Mr. Kamdem's fellow employees signed a document saying they had never seen any abuse, neglect, anything from Mr. Kamdem. And the state tried to say, or I think the witness said, oh, that guy's a chef. So maybe 1 or 2, a handful of these people didn't directly interact with him. But Mr. Mann testified that 90% of the staff is nice. So they're working closely together at both locations. 17 of them, all of them that were asked, said no, they've never seen anything, never heard of remark out of color, nothing. And if Mr. Kamdem had anything, any prior bad acts, any arrests, any bad history from other employers, when he chose to take that stand, you best believe the state of Georgia would come after him. You would have heard all about it instead of them arguing with him about things he's testified to. It's admissible. They could have got, if there was something to get in, that it would be. We knew already what was going to be missing, what we were not going to see. The state may try to make a big deal about the discharge and the itching. The witness told you that it could have been semen, but then it was tested and wasn't. So she told you that's not a conclusion she would jump to, which she didn't, and it was proven to be not. But this is a woman in assisted living who gets her basic needs cared for by other people. It's not, would not be strange. First of all, it could have just been normal. Could have been an infection. It's not related to this case. It's just not. I agree with the state about not leaving your comments at the door. They don't have anything other than Ms. Edgerton's testimony. And we've all had situations where we remember or interpret what we're seeing differently than what it actually was. And there's tons of studies and examples on that. Don't do any outside research. But if you're already familiar. The judge is going to instruct you the proof beyond a reasonable doubt. You can convict only if evidence excludes all reasonable theories of innocence. And there are a number of them. This is the state's favorite jury charge. They talked to you about it already. This does not stand for the proposition that a single witness proves the case beyond a reasonable doubt. That's not what this says. The testimony of a single witness, if believed by you beyond a reasonable doubt, is sufficient to establish a fact, provided you find it sufficient. And you don't have to find it sufficient. And that goes for Mr. Kamdem as well. He doesn't have a burden of proof. He did choose to take the stand. But how do you prove a negative? How do you prove that something didn't happen? That's why there is no burden on the defense. If you believe Mr. Kamdem, that's not guilty. But if you don't believe Ms. Edgerton or have doubts about her testimony, that is also not guilty. The state mentioned this, and the judge did instruct you about sympathy, and the state made it seem like not to feel sympathy for Mr. Kamdem. But I don't think that's what you felt when you walked in here and heard the charges. And we are not asking you to not feel that this was a horrible, tragic situation, if it indeed occurred. It was difficult to sit through the evidence, seeing pictures of the picture of Miss Robinson, hearing about her, Miss Jefferson's obvious pain because she was told that this happened and that was all she had to go on. We are human, and it is valid to feel sympathy. Miss Robinson's heartbreaking dementia and her treatment by the man house are horrible. And sympathy is really the only natural thing to feel about that. And you absolutely can feel it. You cannot base your verdict on it in any way. You cannot base your verdict on sympathy. They're just also going to instruct you that your verdict must be unanimous, agreed to by all. And that's true. But you don't have to agree about why you don't think that this is proof beyond a reasonable doubt, because it's not. So let's talk about the reasons to doubt. The simplest one is that this is just not enough evidence to convict somebody of charges as serious. If you wonder what evidence would have been on the bed, on the sheets, in the same exam, that is reasonable doubt. We don't even have, in addition to the physical evidence, we don't even have like a picture of this room or a diagram of this room. If you wish that there had been a video, because you don't know, you're not sure what to believe, that is a reasonable doubt. You can place, your reason may be Miss Edgerton. Her inconsistent versions of what happened. She's the only person who says any of this. Anything happened, anything that she's claiming Mr. Kamdem said, she's the only person who said any of it. You know how unreliable eyewitness testimony is. And this very same, the only witness, is the witness who destroyed the evidence, who immediately after seeing what she claimed was a rape, then cleaned this woman. Now, I can see maybe making sure she was comfortable, but not destroying the evidence that something occurred, because something didn't. Some of you may put your reason in the culture of secrecy and violating Georgia law of the Manning House. At every level, the head CNA, Sheena, the business office manager, Keisha, the director, Ms. Simpson. I told you in opening that the only video in this case was the external camera. And that was true on Tuesday. But lo and behold, Christy and Charles Mann arrived at court yesterday. And there are videos. This was 2 years ago, over 2 years ago. What is being hidden here? The state didn't have it. The detective didn't have it. The man just showed up with it yesterday. And the state got the video in through Christy, who is the one who told you inaccurately that Ms. Edgerton looked distraught. Please watch it again if you didn't catch that she is absolutely not distraught. But she was allowed to give her opinion about what she thought the video showed. Don't let her inaccurate narration determine what is actually on the video. The state makes a huge deal about Mr. Kamdem. His shirt was untucked and then it was tucked. If it was the other way around, certainly they would have made an even huger deal about it. But the fact that the man's shirt was one way, which was untucked to appear, and then he tucked his shirt in. The man tucked his shirt in. If his guilt is based on him tucking his shirt in because he was about to prepare to bathe her, watch the video again. And if you were in the business of raping people, the scrubs would have been a better call, not a belt with a buckle and zipper. And I adjusted my pants. I've seen you guys, when you stand up during breaks, adjust your clothing. That doesn't mean we're fresh from trying to rape somebody. He was adjusting his clothing, and if you assign guilt based on that, that's frankly frightening. And Christy also told you that they watched other footage from inside the facility. And despite the fact that she's obviously very biased against Mr. Kamdem, she didn't find anything else suspicious in any of the footage she watched. You would have seen it as she had. Another thing that the state is making a really big deal about is Mr. Kamdem not contacting the Mann House. He was arrested. He was in jail based on only Ms. Edgerton's word. And he likely had an order from the court that he couldn't return there because these charges sound so heinous and horrible. Mr. Kamdem, again, if he had anything in the background, you would have heard about it, especially when he chose to take the stand. Room full of people rushed to say they never suspected this. 17 employees said no, they've never seen anything suspicious. No violence, no sexual offenses, no drugs, no disciplinary history other than not completing tasks. And several witnesses were basically begged to say, yes, he's been disciplined or something else. And they all were like, no, only maybe not finishing his laundry. Another reason to doubt the state's case is Mr. Kamdem in his testimony. I'm going to tell you, he was nervous. Not because he was guilty, but because he's scared. He thought his innocence would protect him, but this is now his life, and he's waited a long time. He is hard of hearing, very hard of hearing, and English is not his first language, so please don't hold his inability to communicate like most people can against him. I know he didn't present maybe as he would have liked to if he could hear better, but he wasn't trying to like hide the ball. He was trying to hear and understand the question that was asked and then answer it. He is difficult to communicate with sometimes, but that's not evidence of untruthfulness or guilt. That is just how he, at the age of 74, is able to communicate. And he took an oath to tell the truth, and he did. The only evidence that the state has is inconsistent and uncorroborated, and not only uncorroborated, but it completely disproven by the video about how Ms. Edgerton claims she behaved at this. The judge is also going to instruct you that if your minds are wavering, unsettled, or unsatisfied, if you are unsatisfied with the amount of evidence in this case that you should be, it would be your duty to acquit. Not maybe if you feel like it. Because we understand how horrible this sounded before you heard that there wasn't actually evidence of it. I can't overstate how important the burden of proof is here, because I know that as rubber stamped as it's been all along the way, please do not rubber stamp this because it sounded bad. If you have questions, if you have unanswered questions, look no further than the state of Georgia's table. There is no burden on Mr. Kamdem. If you have questions, that's the state's, that they did not meet in this case. So the state gets to go last. We're gonna try to convince you that this is actually evidence. And I'm gonna go back and sit next to Mr. Kamdem, and I'm gonna think of 10 things I should have said. And I'm not gonna get another chance. But I saw you taking notes. I saw you listening. And I trust that you heard what the evidence is and what it is not. And nothing the state can say makes up for that lack of evidence. Do not let the state make you forget what the evidence actually was. It's way below reasonable. Convicting Mr. Kamdem and not protecting anybody, it's not justice for Ms. Robinson, it's not justice for Ms. Jefferson. It's just not. This didn't happen. And again, if you're back there talking about, maybe this happened, probably, you're all the way to probably, but you shouldn't be. But if you are, if you think probably, that is a reasonable doubt. And you must acquit Mr. Kamdem. Not proven, which is what we have here, elements were not proven beyond a reasonable doubt, is not guilty. And so we are urging you to return with the only verdict that is supported by the evidence. And that is Mr. Kamdem is not guilty of all the charges. Thank you.
Thank you, Ms. Feely. So if you'll stop your screen share, we'll see if the state can get their presentation back up. And then Mr. Dorsey, we'll just have one more transition after that. Because I need to get the jury charge up on the screen. But we'll be taking a break between the two. So do you want me to just reach out to you when we're doing that break? Okay. Okay, Ms. Hall?
Thank you, Your Honor. Good morning, ladies and gentlemen. I want to start off by telling a story. I like to tell stories. So I'm going to start off by telling you a story about I want to tell you a story about a man that went to a border for 30 days. And he had a red bike and a basket on the front of his red bike. There was sand in that basket. And every day that he went to that border patrol searched through that basket, looking through the sand, trying to see what he had in that basket. Every single day. He went for the first day, the second day, the third day. Red bike, basket, sand in it. He stopped looking in the basket, sand, nothing in the sand. Border patrol let him go. On the 31st day, he was walking. The same officer stopped him. He said, "Can I ask you a question? What did you have in that basket full of sand? I could never find anything." The man said, "Every day for 30 days, I smuggled a red bike across the border. But you were so focused on the sand in the basket that you missed it." I implore you, the sand is distraction. What you just heard from the defense counsel is distraction. It's the sand in that basket, so you don't see the evidence. The state presented evidence, and I'm not gonna spend a lot of time because we've all been here all week. We saw the evidence, but I'm gonna go through the evidence. I'm gonna make sure you remember, when you go stand back, what this man, this defendant, did to Ms. Robinson. Let's start by the first piece of distraction that defense wants you to focus on. The man house and what they didn't do. I think we all can agree that we're kind of upset with the man house. Yes, 911 should have been called the first night. We all are in agreement with that. The state would have had more evidence had 911 been called the first night. You know why? Because if 911 was called, she wouldn't have been cleaned up. They would have arrived. They would have told them, "Don't touch her. Let us handle it. It's evidence." 911 is what everyone wants. We would have not been here because of it. We're still here, and 911 was called 3 days later. We're still here, you know why? Because you heard from them. The person who saw this direct evidence with her eyes, she walked into a room and saw what she described to be this defendant having sex with the victim, Ms. Ross. She saw with her own eyes. That's what an eyewitness is. A person that see it with their own eyes. They didn't hear it. She didn't stand outside the door and say she heard a voice. She said she opened the door, turned on the light, and saw this man in the bed of Ms. Robinson with his hands down. She could see his butt. Now I've been trying to figure out, how do you see someone's butt and their genitals are not exposed? How do you even do that? There's no way that your pants below your butt, but your front is not exposed. There's no way. And that's what she testified to. She saw this with her own eyes. She saw him get off of her.
He was in shock, she was in shock, he didn't think he was gonna get caught. But guess what? She picked up an extra shift that night. You heard her, when we played the body cam, she told the officer, this is not my normal shift. I do work it, but I picked up this shift. What would have happened with Ms. Robinson if she had not picked up that shift and was looking for this defendant? Not because he is a perfect worker, but because sometimes he says, I can't hear. I don't understand what I was supposed to do. So what did she say? You heard her sitting in that seat. I wanted to make sure that he knew what he needed to do, what patients he needed to care for. So that the next morning he didn't say, I didn't know. He wasn't expecting that though. He was expecting the fact that she got to work late, she was gonna be busy for a minute. He wasn't expecting it. Don't let them distract you about Sheena and what she saw and how she described it to 15 different people. Because when you think about it, if someone tells you, I saw someone having sex, what is that? How do you have sex with someone without taking your clothes off? If I describe, I'm on top of the patient, the defendant is on top of the patient with his butt exposed, in between her legs, while she's just laying there, thrusting, back and forth, hips back and forth. What is that? I asked her, I said, what does that mean to you? What did she say? Having sex. And I asked an uncomfortable question next. How do you know? Because I do it, because I'm an adult. We all know what having sex is. So she wants you to focus on the fact that in the officer statement that you watched. Now you watched her when that statement was given, and he repeated to her what she said. Now this is right after she wrote it. And he said, and you saw his buttocks. He said, remember, I paused it. I made it a point to go and get her exhibit, defense exhibit 2, to show it to the officer. She didn't write that in her statement, did she? But she had literally just said it to you. Isn't that correct? Say yes. That's distractions, y'all. Those are the things that they do. This is what she's supposed to do. Oh, that's a distraction. She didn't say his butt was showing in her statement. That's this big. But then she showed you another statement that this big, and she says having sex. What does having sex mean? Stop focusing on the fact that she described what he was doing versus her saying what that actually is. That's a distraction. Next distraction. He was cleaning her. Wait. No. He was getting ready to clean her. Oh no, he was changing her diaper. The defense just stood up here and told you that he was changing the diaper. He was getting ready to clean her. Well, yesterday, the defendant told us that he was sitting on the edge of the bed. He was sitting on the edge of the bed trying to pull up. Now, I know that we have different people here in front of me. But I'm gonna assume that we all know what a bed is, the 2 handles on the side. I know I stayed on that point for a long time yesterday. Because I wasn't understanding what he was saying. How are you walk up to a bed that you know is broke, according to the defendant. But instead of, because you got back problems, instead of just pulling it up with your arms, you decide to sit on the edge of it, twist your back, and try to, I want y'all to see me, and try to pull it up. How is that? What is that? It doesn't make sense. Like my co-counsel told you, use your common sense and reason. Does that even make sense? Does it make sense that Ms. Edgerton walked in that room, saw him sitting on the edge of the patient's bed and freaked out? And let's be clear, she never said she ran out the room. She never said that. She said she left to go get her phone. She said she was in shock. She never said she ran. So no, you're not gonna see her in the video running. You're gonna see her leave the room. You watch that, I'm gonna play it for you again. She got to the end and she like, and then kept walking. You see, I play it. She goes and she does exactly what she tells y'all what she did. And who came coming behind her? First he told me I was fixing my clothes. Oh, but I had a video, so I played it. Well, tell me what you were doing to the front. Were you fixing your belt? Yes. Why? I don't know. Oh, you don't have a reason for that. He would have came out better saying he was using the patient's bathroom. That would have made more sense. She called me in the bathroom, so I'm running out, putting my pants up. But sitting on the edge of the bed, she came up with this story about you on top of a 72-year-old woman that has dementia. Yes, he preyed on her. Everybody came here and testified and said, and this he told y'all, she didn't respond. When she went to the man's house, she was talking, not a lot. But Miss Cheryl sat here and told y'all, she did her caretaking sheet, her care plan. When she came in, she was talking. By the time September came, nonverbal. She may yell because they're loud. She may say hi, but she wasn't talking. Yes. He knew what he was doing. He took advantage of being a CNA instead of caring for her. Other people never seem dependent on it. Oh, we're gonna harp on that, huh? Even when he was asking Miss Keisha those questions, when the defense was asking her, what did she say? Well, he's a chef. He wouldn't know anything that he did. You just pulling everything out at this point. But think about what they were preparing for when they were asking everybody these questions. They weren't preparing for a criminal trial. They were preparing for a civil lawsuit. They weren't thinking about this part of it. They were thinking about their business. They going through and asking their employees questions. Did you see something? Did you see something? Did you see something? But what did he do the night of this incident? Shut the door? Turned off the light? He concealed what he did. Who attempts to rape someone with the door open and light on? She talked about the fact that Sheena isn't enough. Sheena is enough. It's so funny that she said that today, because when we started this trial, she focused on Miss Edgerton. What'd she tell y'all? It was only one person that saw this. It was only one person. So it means something different today. Now that we showed y'all that one person, all you have to do is believe that one person, and it is enough to find this man guilty. If you believe what she saw that day was on top of this man, on top of Miss Robinson, this man, thrusting back and forth, having sex, attempting, let's talk about it. I'm saying having sex, because that is what she saw. We charged this as attempted rape. You know why? Because 911 wasn't called. The state's just not bringing charges. We wish we could have charged rape for what he did to Ms. Robinson. We had to charge attempted rape. We couldn't prove penetration. You know why? Just like he knew. Ms. Robinson couldn't talk. She couldn't tell us that there was penetration. I put an expert on the stand to tell you all, you might not even have injuries in any sex cases. That's normal. You might not see trauma at all, ever. You definitely won't see it on Ms. Robinson, who's just laying there helpless. Not fighting back, not doing anything that she can't. Their defense. I'ma just move past this, because we all know sitting on the edge of the bed didn't happen on September 5th, 2021. That didn't bring us here. Sitting on the edge of the bed, that is the reason why you got put out of your place of employment, where you were perfect and never had no infractions. You was never late. It wasn't just because you were sitting on the side of the bed. He got on the stand, he told y'all, I didn't do it. No, I would never do that. How? Someone saw you. You got caught. Someone looked at you on top of a patient, and she didn't know what to do. She walked out in disbelief and shock, like, what in the world did I just walk into? And she did exactly what she told y'all she did. She went to that front and she called the person she was supposed to call. Now, I would call 911. That's what I would have did. But we're not gonna fault Ms. Robinson because Ms. Edgerton or Keisha or Cheryl or Ms. Powell or Ms. Mann did not call 911 when they were supposed to. We can't fault Ms. Robinson for that. Does that mean that it didn't happen to her because 911 wasn't called immediately? No, it just means that's less evidence for us. It means our burden is a little higher. We have to fight a little harder for Ms. Robinson. That's what that means. He was caring for her. Did you hear anybody get on the stand and say he had gloves on? Gloves was up on the bed. There was another clean diaper anywhere nearby. I tried to ask him. He was running from me. I was so frustrated yesterday. Did y'all hear him? Oh, he answered all her questions. He could hear just fine. He could understand just fine. We all understand he can hear well, but he was understanding every question she asked. But when I got out there and asked questions, it was hard. He ran from everything. He ran from every single question I asked. Y'all heard Judge tell me move on multiple times.
Politely.
Sorry.
I said it politely.
In their open, they told you that Sheena mistook what he was doing in their room as misconduct. Tell me if y'all think him being in a bed with a resident, with his pants down, butt exposed. Here we go again, thrusting. What is that, y'all? Pants are down. Imagine Miss Robinson right here. What is that? My little nephew knows what that is. She knew what she walked into. She knew exactly what that wasn't mistaken. That was what he was doing. It's like her diaper pulled down. But he told y'all in that stand yesterday, he hadn't made it that far. He walked into a room, he could smell, she had a bowel movement, he could see that the pad was dry, but yet we still trying to mess with this little thing. We still trying to, is this what he was doing? But I thought he wanted out of it. I was really confused. Because if you knew she had a bowel movement, and you knew the pad was dry because it had been there so long, why hadn't you got your supplies? Why are we still trying to roll her and check her? That's the point I was trying to get to. He just wouldn't let me get there. But y'all saw through that. He wasn't trying to change a diaper. And if he was, if her diaper, if he was really trying, if he came into all that, how'd she get poop all down her thighs? Because he had already removed her diaper when he was on top of her, thrusting her, he had removed the diaper. So now while Miss Edison trying to get you out of the building, guess what she's doing? Because she's incontinent, she's having a bowel movement. And it's running down her leg, because there's no diaper. Although he said he had removed it, who removed it? Oh, Miss Sheena made that up too. Let's talk about the evidence. Miss Sheena. Miss Edison came in here, sat on this stand 2 years after this happened. She told you guys, I saw this. She told you I got to work late because I was with my brother. She told you that. She's being honest. She told you when she got there, everything was done. The stuff that they usually do together was done. She didn't have to do any of that but count fields that he claimed he did that night. Now she been a supervisor, she been in this job over 10 years and was supervisor since the first 6 months of being there. Y'all think she don't know who's supposed to count fields when they're both on duty together? Whether she's late or not. If she's always late, I guarantee you she's still the one counting those fields because it's her responsibility. Yeah, he understand yesterday talking about he counting fields. Okay, you remember nice, so well, how many did you count? Oh, I don't know that. Normally it's 2, normally it's 4. I'm not sure. Oh, so you don't know if it was 2 that night or if it was 4 that night? Okay. Just like I said at the beginning when I first started talking. They're trying to harp on the fact that she either said it was sex or described the act. Either way, it's the same thing. Either way, it's the same thing. I saw him having sex with Ms. Robinson, or I saw him in the bed with Ms. Robinson with his pants down, his butt exposed, thrusting back and forth with his hips. This is what she said. What is the difference? What is sex? What do you do when you have sex? It may be different positions, but what her description was the missionary, which is what Officer Smith testified to. He said, she said, it was a missionary position. He was in between her legs. Don't sound like he was trying to get the side of the rail up to me. Like I said earlier, we charged this as attempted rape. We wish we could have charged it with rape. Because he was on that bed with his genitals exposed, his butt out. Her genitals are exposed. When she goes back to that room, what did she tell y'all? Her diaper was tucked under her somewhere. He moved it. Her genitals exposed. She done had a bowel movement everywhere. And he's thrusting back and forth. That's enough for attempted rape. That's misconduct as an employee. When Ms. Edison testified 2 years after this event happened, this incident happened, this horrific thing that happened to Ms. Robinson, that's how emotional she was. What's her motive? 2 years later, why she come here still saying this? I asked her, do you have any issues with it? She said, no, we don't have no issues. We changed shifts. We've been working together. We were like a family. Isn't that what she said? We were like a family. So you just walk in the room with your brother, cousin, uncle, whoever family member you consider him to be on the side of the bed and you create this entire story. Such a story that she told multiple people and they corroborated what she said and they came here and said the same things about all these years later. She's been doing this for 24 years. And in 24 years of dealing with patients, she's never seen what she saw. She was shocked. Let's talk about some of the employees. I'm not gonna go through all their testimony because y'all heard. But Ms. Sellers was the first one up here after Ms. Edgerton testified. She told y'all Keisha called her. They know Keisha, y'all saw her, she was big. She a big woman. I asked her, I was like, how tall is he? How tall are you? And why would anybody think you would be scared of him? What did she say? Because what I walked in and saw. Because I walked into the room and I caught him. I didn't know when the person got their back up against the wall, I don't know what they'll do. That's what she said. And he's a man at the end of the day. Like, he's a man. She was scared. No, she didn't take off running. She didn't do that. She was trying to figure out what to do. She threatened him that she was gonna call police. We're gonna show the video and we're gonna let y'all see if everything she said was exactly what she said. Well, if you think about it, he corroborated what she said, because what did he say yesterday? She came in the room and said, oh, Eduardo, no, don't stop, don't do that. Stop, don't do what? Pulling up the side of the rail. Use your common sense and reason. That's not what he was doing. But he gave you a little bit. He gave you a little bit of the truth. I don't know why she was mad. She walked in the room and she was upset. Why? You just completed all her tasks and stuff, counting videos. On the video, watch it. When we play it for you, watch it. She comes in with her regular clothes on. She put on her swirls to tie up her hair. She's ready to work. And she's like, where he at? You will see a look for him. But you also heard him say he only work in one area of this institution, this facility. One area, the memory area, the memory care area. But that's true. Even though other people that works at the man house, that operates the man house, they're assigned to different units depending on how many patients are in there. He said that's his assigned seat. He's always assigned to the memory care. Well, if that was the case, why didn't she just walk right down to the memory care? She went through one hallway to the right, and she came back through another hallway that you can't really see, but you see her come from somewhere. She's looking for him. If he's only assigned to the memory care area, why didn't she just start that way? Ms. Sellers talked to Sheena. She knows that she was nervous, she was scared. She said she told her not to call the police. Bad judgment call. Bad judgment call. But we still not gonna punish Ms. Robinson for a bad call on a supervisor. She wanted to call 911. She sat here and told herself that Ms. Ellis said, I told her not to, and don't talk to anybody. Don't tell Earl what happened. She told you that herself. Then she reached out to the man. They were on vacation. He told you yesterday, Mr. Man said, they showed proof that they reached out that same night. But because he was on vacation, he didn't get it. He didn't say, no, I never received any kind of communication. Well, he did say that, but he did also confirm that they sent it, and he saw it in her phone. So Earl comes to sit at the house. He sat there all night. He wasn't on duty. He's just the maintenance man. But he comes and he sits with her all night until the morning. He changed the code. He told you, they taking all these precautions for somebody that's sitting on the edge of the bed. Okay. Let's talk about Miss Cheryl. Miss Cheryl comes in, she talks to you all about how there have been reports of the defendant not doing his laundry. Nothing other than that. Nothing other than that. Just reports that he don't like to do his laundry. He got on the stand yesterday and said, no, I did everything. I did everything I was supposed to do that all the time. Well, golly, I've even not done what I was supposed to do before. Like, we're not perfect, we're human, we make mistakes. You've never not done what you were supposed to do, but she has reports of it. This is the person that doesn't work with him. She works in the office. She has records of it. She said he never actually got written up for it. But the job of the supervisor was coming to tell her it was a verbal warrant. But that night, guess who did their laundry? Guess who had that laundry started and going? Because you wanted to make sure that all your tasks were done. Because you was gonna be busy. That laundry was started that night. The one thing you always got told on about was done in action. Miss Edge said she could hear it. She knew everything was done. The tables were set. Miss Man, he came, he got notification of this. He told him to immediately call 911. His consequence of what happened that night, even though he wasn't there, was $500,000 for someone sitting on the edge of a bed. Okay. Miss Cheryl told y'all, she is a registered nurse. I asked Miss Edgerton, is there any reason why you should be in a patient's bed ever? Her response was, no, and definitely not with your pants down. Ms. Edgerton said, maybe if you fall over into the bed. She's saying she's being who she is. She's being completely honest. I mean, well, if you're trying to get a patient up and you fall over, but he didn't say that. He tried to pick up a patient and he fell over. He said he was sitting on the edge of a bed. Law enforcement came. You heard from Officer Timothy. You heard from Officer Smith. Officer Timothy was just a responding officer. He got the initial statement. They were all huddled in the room. At this point, everybody knows what's going on. The statement's being repeated, but no matter, not telling you how many times this has been at this point, because this is the 8th. Mr. Smith comes, Detective Smith, I'm sorry, comes. He don't turn on his body cam. I really wish he had turned on his body cam. But he had just gotten it. He told you yesterday, they had just gotten here, we know how to work that thing. Now, he said now, if he could redo it, he'll play it the whole time. You know why? Because I'm sure y'all wanted to see Ms. Robinson. Of course you did. And it would have been great to see her in the state that she was in that day. Forget about the room for right now. If he at least had it on when she was getting transported to Grady. But that it doesn't change what happened. It's just less than we have here. It doesn't mean that she wasn't assaulted. It doesn't mean what he did to her didn't happen. It just means y'all don't get to see her in the state that she was in that day, which was 3 days after it happened to her. That's what that means. You heard from when she made it to the doctor. You heard from the doctor who said to you that she suffers from moderate to severe dementia. Do you see how far along this chart that is? All the way towards the end. She's at a point where she cannot communicate. She can't do anything. I told you in my opening, she couldn't stand on her own. She couldn't eat on her own. She couldn't walk on her own. That was his responsibility to help her out. She was depending on him to do his job as a CNA, to help her. Because the doctor told you what state she's in. She's not a woman that can consent, that can talk, that can push, that can do anything to protect herself. she's not able to. Then you also heard from our experts. You heard from the same nurse who told you how traumatizing it is, how painful it can be to have the same exam done. She told you when she put the spectrum in her and wind up, she was pushing her. She was trying to like push her hand away. She showed y'all. And then she can feel and she can try to respond as much as she can, but it wasn't enough where it was interrupting the examination, but she was trying. Wonder what she was doing that night when he was on top of her. She also told you normal was normal. She said, even though you don't see any trauma, you don't see any bruises, that does not mean this lady was not assaulted. If she's just laying there, what kind of assault, what kind of bruises is he leaving behind? She's just laying there. There's no fight, there's no nothing. She's just laying. She told you that. She said how the evidence could be gone because it was 3 days after. That could degrade, which means it could leave. She was bathed every day after this happened. She, as I told y'all, incontinent, so she's being wiped constantly when she uses the bathroom. GBI also told you the same thing. Just because no male DNA showed up in her rape kit does not mean it was none there. It just was not enough to reveal his DNA. See, had 911 been called, maybe we could have had something. Detective Smith told you wasn't a point of taking fingerprints. It wasn't really a point even of pulling the sheet for DNA for touch DNA. We know the DNA goes in there and work with her. We know she's in the bed. But it was important for that DNA that could have been touching her, right? That could have been getting washed off every day up until the 8th. She was told she told officers when she was talking to him that she wasn't even sure if she had a bath that day before she went to grading, but she knows she has a bath daily. So at some point, even the day she went to the hospital, she had been clean. And we know she had been clean because the doctor told you she's incontinent. So someone's wiping her. She's not using the bathroom all day. It was 7 o'clock in the afternoon when they got there. So she had been constantly wiped from the 5th until the 8th. We talked about this a little bit. The man house failed Ms. Robinson. But I want to talk about how he benefited from it. Because that DNA that could have been present, it could have resulted in his DNA being present. So now they can argue that, oh, no, he was sitting on the edge of the bed. Oh, no, he was trying to change her. No, he was trying to fix a bed, which blows me because I don't understand still what that even means. They can do that. You know why? Because 911 wasn't called, because the scene wasn't secure, because they weren't able to pull anything because they had been days. You know why? Because they had never experienced this before. Everybody was confused. All the staff. Starting with Ms. Edison. Because she could have called 911. She didn't have to call Keisha. She could have called 911 and dealt with the business later, right? Keisha, she could have called 911 from wherever she was at. Go to the man house. Something happened, person could be on the run, who knows? Go and figure it out right now. Deal with the man's later if that's their policy. You heard what Cheryl said. Now she don't work for both Mr. Manns. And she said, the older Mr. Mann, the father Mr. Mann, he always said, come and report things to him first. And that seems kind of crazy, right? You know, like, but if that's your policy, that's your policy. She's been working for these people for years. She's been with them for years. Y'all remember how she was affected by what happened by him sitting on the edge of a bed? She got suspended while she was on vacation though. Well, how I get suspended? I wasn't there. The policy that I'm aware of says, contact us first. That's what I'm aware of. So that's what I did. I contacted you first, but I get suspended. So you know what she did after that? Y'all got it. I'm gonna resign. She told you, she resigned after they suspended her. Where's the loyalty for her? That's how she felt. Why are you suspending me? She told y'all this then. I'm a scapegoat? How? That was a policy that she understood. She didn't always work for Mr. Mann's son, Charles Mann. She didn't always work for him. He benefited from the man house felon, Ms. Robinson. He benefited from that. If she had called 911, the charge would be rape. let's be honest, we know what he was doing on that bed with her, with his butt out and his them hands down. He was having intercourse, we just can't prove it. But what we did prove was attempted rape. That's what we did prove. Now I want y'all to try to help me make this make sense, please. Because he walked in the room, he smells Ms. Robinson has bowel movement. There's some type of policy where you check the patient first, see what you need, what kind of supplies you need, then you come, you change your. I think a lot of you guys have children. And if you smell that your child has used the bathroom in his pamper, what do? You know, like, well, let me assess the situation, let me make sure. That sometimes you do, because y'all know, I don't have kids, but I know sometimes false alarms, and it may be just passing gas, right? But most times y'all know, right? No, he walked in, he smelled bowel movement, he saw the pad was dry, that had already had bowel movement on it apparently, but you're still trying to turn her to assess, to figure out what supplies you need. Does that make sense? Use your common sense of reason. Does that even make sense? He's trying to remove some type of removable side railing from the bed. Use the other side. If it was that difficult, use the other side. The other side broke. Because that's not what he was doing. He was in that room assaulting Miss Robinson. That's what he was in there doing. He said she walked in upstairs. Why? She was just looking for you. Where you at? If he could have just been checking the rooms. Oh, there you go. Well, come on, let's talk about what rooms you got tonight. So you ain't confused in the morning. Make this make sense. His pants were down. He said his pants never were down. When I asked him, he said his pants were never down. So then why when she went in the room and come back out a minute later, he's walking behind her? Why is he doing this?
So you've got 10 minutes left.
Why is he doing that? Because he's fixing his clothes. Because he had just been caught. That's why he's doing it. I asked him, were you fixing your belt? He said yes. Must have wore him out with all the questions. He just said yes. I said, well, why? I don't know. He has no idea why he was fixing his clothes after coming out of the room when someone's accusing you of being on top of a patient with your butt exposed, what they perceive to be having sex with her. He said the next morning he received a group text message. Remember from Sheena, this is what they do, receive the group text message. But then when I asked him, well, why didn't you ask anybody else of higher authority, what's going on? She wouldn't listen to me. He said, what? I don't know the number. Oh my God. You've been working this job for 8 to 9 years and you don't know a number? Well, we can Google the number for the manhouse, I would assume. I've never tried, but I would assume. He said he don't know a number. He never came back. He never filed a grievance for being unfalsely charged, fired. He never did anything. He walked away from that instant, that what he did that night, and he thought that he was free. Nothing was gonna happen. If I don't go back, that's the end of it. He didn't show up in his shift the next night. She talking about he was in jail. He was in jail. Well, they didn't report it until 3 days later. What happened Monday night or Tuesday night? But he ain't never late, y'all. He ain't never ever been late for this job. Let's go over the video. And I want you to pay attention to this video. While she's pulling it up, I'm gonna tell you what to watch for. When you see this video start, you saw it yesterday, but I'm gonna point some things out to you. The defendant goes to the memory zone, and I'm gonna talk while it plays. Watch the defendant. At this time, it's September the 5th at 12:04 a.m. The defendant is in the memory zone area, memory care area, and it's 12:04 on September the 5th. And at 12:08, you'll see Miss Edgerton walk in. She told you she was late for work that night. She walks in at 12:08, and you'll see her with her regular clothes on. Watch how you look to the right, look down that hall. Yeah, he talked to her when she first got there. Now he makes sure, okay, I don't see her. He's going back there to Miss Robinson's room. The next clip you will see Miss Edison with regular clothes on, getting ready for work. You know how she had on regular clothes? Because the next time you see her, she's gonna have her scrubs on. And you will see her tying her hair up. She's ready to go to work. There she goes. Those are her street clothes, her regular clothes, her clothes she wear outside. The next time you see her, she'll have her scrubs on. Now you see her, she have her scrubs on, 12:14 a.m. Now he been gone since 12:04 down this hallway. She looked for him, look at him, where'd he go? Eduardo. And then when she said she was calling him, you know what happened to him that night? His hearing failed him. And she told y'all, she said, before she opened the door, she knocked and opened it. He didn't hear that. Because like the defense said, he's hard of hearing. Had he heard her calling for him, he could have gotten up. He didn't hear her. Multiple people testified to the fact that he has hearing issues. You saw it yourself. The defense told you. At 12:26, you will see her walk. She's gonna come from this way. You're not gonna be able to see the door, but right here at the bottom of your screen, she's gonna walk straight into the memory care area. You see her? 12:26. There. Sorry, 12:25 and 41 seconds. That's when she walks back. She's going to Miss Robinson's room. She's now opening the door and catching him on top of Miss Robinson. Watch when she comes back. At 12:26:41, there she goes. Guess who's coming right behind her? Did she testify that she was going to get her phone and when she turned around, the defendant was right behind her? Look at him come out, fixing his clothes. Look at him fixing his clothes. He went in with his shirt out, and now his shirt is in, and he's fixing his belt. And he don't know why. Now he's going to talk to her. She testified that he tried to tell her, I'm sorry, let me explain. I was going through things. He tried to do all that. That didn't work for 4 minutes. So look, now his shirt is out his pants again because he fixes stuff. Consistent with what she said. When he came up on her, he was still fixing himself. Now he's pulling his shirt down and getting back in order. And you saw him all the way in order. She said she went to another room and saw him from that room go back to memory care. You just saw him do the same thing. What's consistent? This is direct evidence. This video is direct evidence for what she testified to. You will watch him get his stuff and leave. You see what time it is? 12:32. And what time did the officer say yesterday he left? 12:35. He left at 12:35. He grabbed his stuff and he left. You see the ring camera? It's 12:35. And she's still like, go, look at her hand, go, just go. She told you that's what she was doing. He don't want to leave. But those two know what happened. We weren't there, but they know, he knows what he did to Ms. Robinson. And he knows that she caught him red-handed. You walk in a room, you have children, and they have somebody in bed with them. You know what's happening. They know what's about to happen to them as a child in your house with someone in the room. That's what happened there. That's why he's standing there and don't know what to do. That's why he sits in the parking lot. I implore you to think about all the evidence that you saw in this case. Everything that you heard these witnesses testify to, everything that you heard Ms. Edgerton testify to, all the cooperation, I'll focus on the report that says the word sex versus he was on top in her legs, the run thing. Just because she didn't describe it every time, she was uncomfortable when I was trying to make her talk about it. She didn't even want, she kept describing it to me. Tell me what is that? She didn't want to say it. When she wrote her report, sometimes she put sex and sometimes she actually described what she saw. This is all the things that make him guilty. Hands down. I'm sorry, I'm sorry, I'm sorry. Please let me explain. I was going through something. Well, so was Ms. Robinson. And now so is Ms. Jefferson. They were going through something too. We're gonna just let that fail. I implore you to be, the main house failed her. Let's not fail her today. Be her voice by bringing back a verdict. Now it's working. That's what technology does. It messes you up. But at the end here, it was nice. He's guilty of attempted rape. He's guilty of elder abuse. He's guilty of sexual contact by an employee. He's guilty of that. He had no explanation for why he was in that room like that. Well, he said he was sitting on the edge of the bed. We don't believe that. Reason, use your reason. She didn't deserve this to happen to her. She was violated in the most horrific way. She had dementia, and he took advantage of that. He knew he could. He knew he could. He told you himself, she's always late. Miss Edgerton is always late. I asked you to go in the room, and if you need to see the video again, because I had to rush through it, ask the judge, he'll let you. But I asked you, when you go back now and deliberate, think about everything that you heard. Think about all the direct evidence and all the circumstantial evidence from Blackman's parents. In and out, he don't know why. Think about all that. And think about Ms. Robinson. And I ask you to bring back guilty on all counts. Thank you.
Thank you, Ms. Hall. Ladies and gentlemen, we're going to take a quick break because my presentation to you is much less dynamic than what you heard from the three lawyers who were just arguing to you what they think the facts have shown or not shown. We'll keep it to probably a little under 10 minutes because once I charge you, you will get the physical evidence, you'll get the indictment, the jury charge, a verdict form, et cetera, and you will be deliberating. So quick break just to refresh you, clear your mind, and then we'll do the jury charge. Please don't talk about the case during your break. Ms. Hall, anything before we break?
Nothing else that, Your Honor.
Ms. Feely?
No, yeah.
Okay, let's get Mr. Kamdem a break, and Mr. Dorsey, if you could, should I just see if I can join it?
No, it's in.
It's in, you think it's working? All right, talking tough. What's on it? We're on it. Great. Okay. All you did was change the, okay. I know, I'm gonna get her off the camera. That was for the lawyers who were in the middle there. There you go. Everyone liked the orange sweater. You know, it's pumpkin spice time and everything. So we got the fall, the autumnal colors. All right, I'll be back out in a couple minutes. We'll see if the jurors are ready and I will give them the charge. If you could, in the interim, if you don't need a break, just talk about what exhibits are going out and not at least start that conversation. Thank you.
But, I mean, I have.
Okay.
So.
Now that's the next one.
Oh, yeah, save us out, right, the business records are out. Okay.
The 13-foot is coming.
They can get it whenever, they don't have any place.
I need to buy more on it.
Where?
Thank you. I don't want to touch it, but, yeah. So do we, I think we send.
Well, they can't be.
Yeah. And then they just watch it, and the same thing with chemistry, it's just a regular. D1 is the, I remember stating that, you know how to do that?
Yeah, D1 was the police statement, D2 is the man house.
Oh, that's part of the records, I think.
Which is already,
So I think we're, gonna just go records. Anything else? I got those.
All right, so this file here and all the documents.
So we don't get it for the jury no more? All rights with juries? I'm just saying. You keep your butt too low, yeah?
Yeah, that's what we do.
So you just don't have to break something.
No, my mom did she ran a cart. I'm talking
Oh,
about.
and shop.
Yeah.
Well, that one was a guy, 30, you said more than that. God, 30.
Sure, I'm gonna tell you, like, I don't know what I said, but I don't
You
know.
said it's okay.
I'm not telling you.
I know you like to keep talking about it, but then like maybe get my tour. It was the baby toe or the big toe?
The big
Oh, you were still don't choose. I'm on those skills, I might be, I look like I made a skill.
Yeah. Oh, he likes that. Look at that, look at that. You made his day today.
Hey, you know, I got.
Yeah, I look like I
what,
made
about
a skill.
4 days, we've been together for 4 days. Yeah, y'all all right, somebody look, still ain't paying attention to play.
You know, this is funny, it's too many of this that I hear all day.
Yeah, I know.
How do you deal with it?
It's
Yeah.
hard. Sometimes I get confused, I'm like, where was that the other day, right?
No, how you deal with the stress, what do you do to,
People, I talk to
no, to take care of yourself? Because this is the secondary trauma.
I know I like helping people though. You know, I like to talk it out.
But I know, but the thing is, it's like,
So I try to be like an open book, I'm just saying, cause I like.
you're not answering my question.
I am, I'm
Wait a
telling you, like, if I just start thinking about yourself, I just start talking, I'll talk it out.
You talk it out,
Yeah, I talk it out.
because the thing is, it's like, you just almost like me, like, you deal with it, you hear it.
Here
You
it
know,
is,
the judge
see,
hears
here it
it.
is, see it. Yeah, that's how good I feel. Yeah, I just like, they don't pass. Yeah, well,
It's a lot, absolutely a lot. And then I was in how like, because they don't seem to have a secondary trauma, like here is trauma, what do you do like to?
we work so much, so.
Severe. Yesterday.
Been treated. But when they 30%, yeah, I just started to,
Really? Doesn't matter.
Are you just gonna hang out in the fifth floor office?
Do you need to be somewhere else?
No, I got a little car, but. Hurry up, my parking. Yeah, it's just, the office is so far from here.
I know.
It's kind of. I have time to go back.
In 12 months.
Yeah, not the documents, just the other stuff. Yeah, that goes. Mhm.
Oh, yeah.
Yeah, I think we're looking to do that at 2 or 2:30. It'll be after lunch.
Okay.
You want to take them back down? Okay. All right, Ms. Hall, are you ready for the jurors to come in for the charge?
Yes, Your Honor.
All right, and did you or Ms. Marsh talk with Ms. Feely about what exhibits go out with the jury?
We did, Your Honor.
Any issue from the state?
No issues from the state.
Great. Ms. Feely, are you ready for the jury?
Yes, you are.
And any issues about which exhibits go back with the jurors? Okay, great. Let's bring the jurors in, please.
All right, so jury.
All right, everyone can be seated. Welcome back, folks. It is time for the jury charge. I want to tell you a little bit about how that's going to work. I now need to instruct you on the law that you must apply to this case. You'll be the fact finders. I'm the law giver. That's sort of the connection here. And the law is all contained within this document. A few things about this. One, I'm about to read it to you. Two, you'll get it during your deliberation. So you should feel free to take notes, but this specific document is going out with you, and this is what I'm reading from. Three, what I'm reading will also be on the screen. I have learned from jurors that they sometimes connect more with the language if they can see it while it's being read. You don't have to follow along. There's no bouncing ball, but as I'm going from charge to charge, it'll be on, hopefully, those two screens. Four, there is a little legalese in here. I do my best to make the jury charge accessible so that I'd understand it and anyone else would. There's certain legal concepts that higher courts have said, nope, you have to define it this way. So if there seems like there's some stilted language in there, I'm not trying to be fancy, but some appellate court has said, nope, when you're talking about X, you need to use these words with the jury. So it's meant to be accessible. Hopefully it is. And again, you'll have this document to pour over, should you need to, during your deliberations. So this is the jury charge in State versus Kamdem. Let's see if I can get it to, all right, and make that small. Perfect. A grand jury has indicted the defendant for 3 crimes. And again, you'll have the indictment, this document, with you during your deliberations. The criminal attempt to commit rape, improper sexual contact by an employee, and abuse of an elder person. The defendant has entered a plea of not guilty to these charges. Neither the indictment nor the plea of not guilty is evidence. The defendant is presumed innocent. This presumption remains with him unless it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of one or more of the crimes charged. The state must prove beyond a reasonable doubt every material allegation in the indictment and every element of each crime charged. And I will be telling you in just a few minutes what those elements of the 3 crimes are. There is no burden of proof upon the defendant, and the burden never shifts to him. If a defense is raised by the evidence, the burden is on the state to disprove that defense beyond a reasonable doubt. The state is not, however, required to prove the defendant's guilt beyond all doubt or to some mathematical certainty. A reasonable doubt means just what it says, a doubt based upon common sense and reason. It is the doubt of a fair-minded, impartial juror honestly seeking the truth. It does not mean a vague or arbitrary doubt, but is rather a doubt for which a reason can be given. It's a reason that arises from your consideration of the evidence, lack of evidence, or conflict in the evidence. If, after considering the evidence, your mind is wavering, unsettled, or unsatisfied, that is a doubt of the law, and you must acquit. But if such doubt does not exist as to the defendant's guilt, you would be authorized to convict. Evidence that merely places upon a defendant grave suspicion of the crimes charged is not sufficient to authorize a conviction. It's my responsibility to instruct you on the law, which is what I'm doing right now. You are bound by these instructions. It is your responsibility to determine the facts from the evidence presented. You must then apply the law that I'm giving you to the facts that you find. You must decide this case based only on the evidence presented here in court during trial. That evidence consists of testimony and exhibits. Evidence does not include the indictment, the plea of not guilty, anything said by me or the lawyers to include their opening and closing remarks, nor any question posed. Now, the evidence that you did receive may be direct, circumstantial, or both. An example of direct evidence is the testimony of a person who asserts that she has actual knowledge of a fact, an eyewitness. I saw this happen. Circumstantial evidence is proof of one or more facts that tend to prove or disprove some other fact by inference. There is no legal difference in the weight that you may give to direct or circumstantial evidence. In considering the evidence, you may use reasoning and common sense to make deductions and reach conclusions. However, you may convict only if the evidence, whether direct, circumstantial, or both, excludes all reasonable theories of innocence and proves the defendant's guilt beyond a reasonable doubt. You must determine the credibility or believability of the witnesses. In deciding this, you may consider all the evidence, the witness's manner of testifying, their basis for knowing the things about which they testified, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their possible bias for or against a party. The credibility of a witness may be attacked by disproving facts to which the witness testified. Your assessment of a witness's credibility may also be affected by comparing that testimony to statements that the witness made before trial. You must decide whether there is a reasonable explanation for any inconsistency between a witness's pretrial statements and trial testimony. If a witness's credibility has been attacked, you may consider evidence offered to support the credibility of that witness. You've also heard from witnesses who were designated as experts. Experts are those who, because of their training and experience, possess knowledge in a particular field that is typically not known to the average person. Experts are permitted to give their opinions based upon that training and experience. Testimony of an expert, like that of all witnesses, should be given only the weight and credit you believe it should receive. The testimony of a single witness is sufficient to establish a fact. Corroboration of a witness is not required, provided you find the witness's testimony to be sufficient. A crime occurs when the law is violated by a defendant's intentional action. Intent is an essential element of every crime. Criminal intent is not the intent to violate the law, but means simply the intent to do the thing that is illegal. Intent may be inferred from the evidence. It may also be inferred when it is the natural and necessary consequence of an act. A defendant is not presumed to have acted with criminal intent, but you may find that intent, or the absence of it, from consideration of words, conduct, demeanor, motive, and other circumstances connected with the acts for which the defendant is being prosecuted. venue. Criminal cases must be tried in the county in which the crimes were committed. This question of venue, that is, were the alleged crimes committed here in Fulton County, must be proved by the state beyond a reasonable doubt. Criminal attempt to commit rape. A person commits criminal attempt to commit rape when, with the intent to commit rape, that person performs any act that constitutes a substantial step toward the commission of the crime of rape. For rape, the state must prove that the defendant, 1, had carnal knowledge, 2, of a female, 3, forcibly, and 4, against her will. Carnal knowledge means sexual intercourse, which is any penetration, no matter how slight, of the female sex organ by the defendant's male sex organ. Force means acts of physical force, threats of harm, or intimidation. And finally, against her will means without her consent. So that's the definition of rape. Reminder, the defendant is charged with criminal attempt to commit rape. A couple of comments on consent. First, the state must prove that the alleged victim did not consent to the attempted sexual intercourse or the sexual abuse. If you find that the victim was not mentally or physically capable of consenting to the sexual acts alleged, then you would be authorized to find the defendant guilty of attempted rape and or sexual abuse. Similarly, if you find that the victim submitted to the sexual acts that are alleged only because of fear or intimidation or because of force that the defendant used, then you may find that the acts occurred without the victim's consent. The second alleged crime is improper sexual contact by an employee. For improper sexual contact by an employee, the state must prove that the defendant, 1, was an employee of a care facility, such as an assisted living facility, and 2, knowingly engaged in sexual contact with another person, 3, whom the defendant knew or should have known was a patient or resident at the facility. And for this statute, the term sexual contact means any contact involving the intimate parts of either person for purpose of sexual gratification. Abuse of an elder person is the third alleged crime. A person commits the offense of abuse of an elder person when he knowingly and willfully inflicts sexual abuse on the elder person. Elder person means a person 65 years of age or older. Sexual abuse occurs when a person supervising the welfare of an elder person forces that elder person to engage in any of the following conduct for the purpose of sexual gratification. A, lewd exhibition of the genitals or pubic area of either person. B, physical contact with either person's unclothed genitals, pubic area, or buttocks, or with a female's nude breasts. Or C, penetration of the vagina by any object, except when done as part of a recognized medical or nursing procedure. Ladies and gentlemen, you should consider each count individually. The defendant may be found guilty of some, all, or none of the charges. If, after considering the evidence, together with this charge, you should unanimously find, beyond a reasonable doubt, that the defendant did commit in Fulton County any of the crimes alleged in the indictment, you would be authorized to find him guilty. And in that event, the form of your verdict would be, we, the jury, find the defendant guilty. And on this verdict form for that offense, you would check the word guilty. If you do not believe that the defendant is guilty of a particular offense, or if you have any reasonable doubt as to his guilt, then it would be your duty to acquit him, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. And on the verdict form for that offense, you would check not guilty. Whatever your verdict is for a particular count, didn't change the slide, sorry about that. That's what I just read. Whatever your verdict is for a particular count, it must be unanimous. Your verdict must also be in writing, signed by your foreperson, and dated. By no ruling or comment that I have made during trial have I intended to express any opinion about the credibility of witnesses, the evidence, or the possible guilt of the defendant. Your verdict must be based solely upon your consideration of the evidence, according to the laws I've been giving you in this charge. It is your duty to consider the facts objectively, without favor, affection, or sympathy for anyone. It is also your duty to report to me if you perceive that a fellow juror is making decisions based upon improper considerations of race, gender, religion, or sexual orientation. You are the fact finders in this case. You are not to concern yourselves with punishment. That is a role for the judge. One of your first jobs in the jury room will be to select a foreperson who will preside over your deliberations and who will sign the verdict to which all of you freely and voluntarily agree. You should start your deliberations with an open mind. Consult with one another and consider each other's views. Each of you must decide this case for yourself, but you should do so only after a discussion of the case with your fellow jurors and a careful consideration of the evidence. During your deliberations, you must not communicate with anyone outside your group about this case, nor may you conduct any research. You have all the evidence in this case, and it would be improper to supplement it with any outside information. And to assist you in complying with this direction, Deputy Gordon will be collecting all of your electronic devices, including Apple Watches or equivalents, while you deliberate. We'll hold on to those. I promise you'll get them back. But while you're in there deliberating, it is you and the evidence and the whiteboard and the markers and your pads, and no Google or Bing or anything like that. Going forward, should you need to communicate with me for any reason, it must be in writing. Upon receipt of your question or note, I will confer with the lawyers and share with you whatever response I am allowed by law to give. And on that last point, you may have a great question. The answer may be you have to rely on your collective recollection. I warned you at the outset, you don't get a transcript of the proceedings. So if your question is, hey, could you remind us what witness X said? My answer will be, nope, you have to rely on your recollections. I may have a real clear recollection, or the lawyers may, and they'll be frustrated, but that's not the way in which I can assist. But if it's a legal or technical question, write it down, and I will provide whatever answer is appropriate. And with that, I am done. In a moment, you are going to retire to the jury room with the instructions I just read, the verdict form, this indictment, and the evidence that has been admitted. It is a little before lunchtime. It's helpful if you all are going to break for lunch that you say, hey, we're going to do this now so that I can release everyone for about an hour. And otherwise, we're kind of hovering, waiting for you because you could have a question at any time or a verdict at any time. So what I'm going to ask you to do is go back and figure out how you want to work this. You may say, no lunch there, enough pretzels back there. We're just going to deliberate. That's okay. You are in charge now. You may say, let's eat first and then begin deliberations. We will go as late as you need to go today. And if you decide we're stopping at 3 and we want to come back tomorrow, we'll come back tomorrow when you want to come back. I'll probably encourage you not to stop at 3 if you're still deliberating, but you are very much in charge of the clock now. My one request is just figure out the lunch thing so that I can release everyone for about an hour if you're going to do that. When you are outside of the jury room, you should not be deliberating. So if you take a break at any time and 3 of you go down the hallway and 1 of you goes that way, the rest of you in the room shouldn't be talking about the case. You need all of you in the room and that door closed when you're deliberating. So if you break for lunch, that means no deliberations during that lunch. You can all eat together, you can eat in subgroups, but no talking about the case. Last thing, before you decide what you're going to do for lunch, I need 12 of you to go in the jury room, and Mr. Guadagna and Ms. Saylor, you stay put. I'm going to talk to you for a minute, and you're going to get to go to lunch when everyone else does. You're just not going to be part of the discussion of when lunch is going to be. Any logistical questions? All right, the 2 of you stay here. Everyone else, please, to the jury room.
All right, sir.
You two are alternates. You are here, you've been here all along in case we lost one and then two jurors. 12 is the number of jurors who deliberate. I'm going to ask you all to stay here today as long as your colleagues are here. You'll be in a different jury room. You'll be able to keep your electronic devices if you have any and can use them in any way other than looking up things about this case. I need you to stay in that little bubble, the information zone that you've been in, the quarantine zone. If this group decides, hey, we're going to go to lunch now and be back in an hour, you should go to lunch with them. It's fine to interact with them because they cannot talk about the case when they're outside the jury room. But when they're back in there deliberating, you're going to be in a separate space. If for some reason we lose a juror, one of you will join that group. They will reset and restart their deliberations with you as a deliberating juror. Both of you saw and heard the same information that those 12 did. And we always have alternates because you never know when, my kid got sick, I can't come anymore. And we don't want to have to retry this case because life happened for a juror. Should the jury reach a verdict today, I'll accept that verdict. And once I accept it, assuming there's not some technical issue with it, we'll bring you out here and then you'll be part of the wrap up that happens. So I promise we won't forget about you back there. If you want to go get your devices or whatever you've got in the jury room, Deputy Gordon or Sarge will get you situated in that room. Where I'll ask you to wait till we figure out what the lunch situation is from your colleagues. Okay? Thank you. They want to go to lunch.
30, 35, 40 minutes.
Why don't we say everyone should be back at 12:30? Want to see if that works for them? And if they can say no time X, but why don't you say, should we assume everyone's back at 12:30? Because I don't want them to get any of the stuff till they're out. So we won't give them the evidence or whatnot till then.
Well,
12:30? Okay, so they're just going to head out now. All right. Ms. Hall, do you have any exceptions to the charge that was given to the jury?
No, Your Honor.
Ms. Feely?
No, you are.
All right. Why don't you all aim to be back here around 12:30, just so we all know that deliberations have started. And we will get to the jurors, all the things I said that they get. We'll get our alternates situated there. And then if I can have one phone number for each side written on a single piece of paper, we'll call you whenever there's a question or a concern or a verdict. You're welcome to stay here the whole time. But if you want to retreat out of 8D, I understand that. I just need a number that we can call that will get a prosecutor and one of Mr. Kamdem's lawyers back here on pretty short notice. Anything else, Ms. Hall, from the state?
Nothing from the state, Your Honor.
Ms. Feely?
No, you are.
I want to thank both sides for your hard work on this case. You packaged a lot into a relatively short period, and the jurors now have their work cut out for them. I will be back in here at 12:30. Kind of jazzed up the lunch break slide. I like that. All right, Ms. Rivers, are you ready? We'll go back on the record in State versus Kamdem. It's a little after 12:30. Do we have all 12 jurors back? And they're all in, right now it's the 14. If you would extract the two alternates, if you remember who they are, we'll eyeball them as they walk through and make sure it's the alternates. And tell them to bring their stuff.
Yeah. Didn't close the door.
All right, Ms. Hall, anything we need to discuss before Deputy Gordon takes that little crate in, which has the evidence, verdict form, indictment, and jury charge? All right, Ms. Feely, anything from the defense?
No, Your Honor.
Okay, Deputy Gordon will then fill that with the electronic devices. They'll be back in chambers, and I will call you all when there is a question or a verdict or whatever may be the next output from the jury. Thank you.
Okay.
Yeah.
All I've heard is that they are a big fan of Ms. Wood's hair. Red, exactly. I'm hurt that, I guess they don't ever see me because I was waiting for them to say something about my hair.
We have a cult following.
What's left? All right, Ms. Rivers, are you ready? Okay, let's get on the record, please. We are, the jury is deliberating in the Kamdem trial, but we have Mr. Lewis here. Good afternoon, Mr. Lewis. Good to see you. This is position 11 from our trial calendar, 22 SC 183910. Mr. Lewis is represented by Ms. Feely. She is here, as is Ms. Primovic. Seated on either side of Mr. Lewis, we have Mr. Abate from the DA's office as the prosecutor, and Mr. Lewis was on the trial calendar. Both sides had announced ready, and then I heard there might be a non-trial resolution. I think that's what we're going to go through today. Are you prepared, Mr. Lewis, at this time to enter a plea in your case?
No, I was talking over with my lawyers.
So I need you to move the microphone a little closer to you. Ms. Feely, I'll let you answer. I didn't mean to go directly to your client, but of course I need to hear from him that he's ready to go forward.
So me being tied up, unfortunately, I do need a little bit more time to speak with him today.
Okay.
If that's possible.
Sure. Why don't you share with me, so we're all hearing the same thing, what you understand the offer to be?
So what I've conveyed to Mr. Lewis is that it would be a plea to voluntary.
Voluntary manslaughter, which has a maximum of 20 years, takes a life sentence off the table for Mr. Lewis.
Right, and that the state would recommend 7 to serve.
20 to 7.
20 to 7.
Okay. With the balance probated?
Yes.
Okay. So it would be 7 years to serve. Mr. Lewis would get credit for the 400 plus days that he's been in custody. So he's already done a chunk of that. And that's a parolable offense, unless there's a recidivist notice that I don't know about.
He is, well, we'd be going where it's unrecidivized, but he is an ANC recidivist.
So if he went to trial and were convicted of murder, the only sentence I could give him would be life without parole.
Yes.
So he's not only moving away from life without parole, but life by the state agreeing to move forward with a lesser included of voluntary. And would the other counts in the indictment be dismissed? There's some gun charges that one would be consecutive and there's et cetera.
So the count 5, possession of firearm and commission of felony, we would offer to suspend that. And then 6, possession of firearm by convicted felon would just be a concurrent sentence.
Run it concurrently. Okay, got it. So as I'm understanding it, Mr. Lewis, the state would recommend a sentence of, it really would be 25 years to do 7, 7 to serve, 13 on probation, and then the last 5 would be suspended. There's a firearms offense that it's a mandatory 5 years consecutive, but it can be suspended or probated, and the recommendation is suspend. So you'd serve more time in custody. How much more? TBD. That's a Department of Corrections and Pardons and Paroles decision. The most it would be 7. Then you'd be on probation for up to 13 years. If you did well on probation, that would fairly quickly become non-reporting. Then it might be terminated early if everything was going well. That's what the state's willing to offer today.
To make sure that the spirit of my offer is the same, what I would do is I'd offer 15 to serve 7 on the voluntary manslaughter. Since there's a gun charge, it would be 5 years, but I would even suspend those 5. So the last 5
Got it.
really on probation.
So we don't even get into the 25 realm. Okay, so now it's 20 to do 7, still 7 to serve, parolable, and then it would be 8 years on probation. That's the 15 to do 7 for the voluntary, the death of the victim. That gun charge, which has to run consecutive, which is come after the 15, and it would be suspended. I know you've got some numbers bouncing around. The one that you should be laser focused on is the 7, which is very different from life or life without parole. And I'm sure you get that. I'm going to let you talk with Ms. Feely some more. She's understandably been focused on the gentleman who is on trial right now. The other thing I want you to process is that we will go to trial on your case during this calendar. If you don't accept this offer, the offer, I assume, will be withdrawn. That's the state's choice. And then you're back to your recidivist looking at life without parole, and we'll press on and see what a jury does. So I just want to make sure you appreciate what's behind curtain number one and behind curtain number two. Do you have any questions of me? I'll let you ask all the questions you want of Ms. Feely and Ms. Primovic, because I'm going to be around all afternoon while this jury deliberates. But when they're done, I want to be ready to move on to the next case. Do you have any questions for me?
Am I the next case?
I don't know. Could be. But you need to be thinking about not what's up next as what's the value of 7 years to serve versus the likelihood of what happens at trial. And that's what you talk to your two lawyers about. Okay?
Yeah, so the record is clear too. What I have made clear to both defense counsels that this offer can also be non-negotiated, where they can ask for less than 7, and the 7 would be my cap. I'm not going to go above 7. If they ask for 5, 4, probation, whatever it may be, my offer is 20 to serve 7, and there's no penalty for his counsel asking Your Honor, who ultimately determines the sentence for something less than 7.
Got it. So you don't back out of the deal if Ms. Feely comes back and says, effectively time served. Judge, you should sentence Mr. Lewis to 1 year and 6 months, or whatever the math would be for time served. She's free to recommend that.
No, because I'm not going to penalize him for, having those rights, his counsel being able to ask that, and ultimately, Your Honor, is the arbiter of the sentence, and whatever Your Honor deems appropriate, the state will accept.
Got it. Okay. So did you follow that? Ms. Feely is going to be able to advocate for whatever you all conclude is a reasonable sentence on your side. So it's what we call a non-negotiated plea. The state, you know what they're going to recommend. He said it on the offer. He can't on the record. He can't walk that back now. Mr. Abate can't. Ms. Feely, if we go forward with a plea, will be free to recommend what she thinks is reasonable. And she knows the facts of the case a whole lot better than I do. Okay. I think you've heard enough to have a meaningful and hopefully productive conversation with your two lawyers. I'd ask you all to go back and confer a little more. Ms. Feely, I don't know, you have the walk-in who's coming as well, so we can she's here. Okay. Would it be okay for Ms. Primovic and Mr. Lewis to do some talking initially, just so we can clear up your other client situation? And then you can join them, and then I'll sit tight while this jury deliberates. Thanks.
Thank you, guys.
That's why you handle this matter. Can I just step to Lambo to finish the hearing?
Sure, please do.
Yes.
Although, do we need, before you go, and you can just get Ms. Hall or Ms. Marsh to come back in here, we'll need a prosecutor. This is a discussion about lifting a bench warrant. It's not a real complicated one, but I don't want to have it without a prosecutor here. Okay. Ms. Feely, if you could give me nope, I've got it right here. Nope, I just got it. Thank you.
Judge, I think Ms. Clark was supposed to be handling the bench warrant. Do you want me to reach out to her?
No, Mr. Abate is saying he's here. He'll do it.
Okay,
I appreciate that. I bet you're right. It's not till 3 was on the calendar for, but everyone's here, so I don't want anyone to think that Ms. Clark is late. That's not for 8 minutes, but because we've got everyone here, I thought we'd just knock it out. I'm just pulling the case up now. Okay, I don't think we need to make a record of this unless it gets real complicated. I'm happy just having an informal discussion. So you're Ms. Jackson?
Yes, sir.
Hi, Ms. Jackson. And you are charged with aggravated assault and a couple other, 2 other charges. And you had a final plea date on the 19th. So just a few days ago. You weren't here. So there was a discussion about whether I sign a bench warrant. Your case was moved into judicial hold. A couple days ago, a change of address was filed. I'm going to have Ms. Feely explain what was going on. I may have a few questions to understand why you weren't in court. The prosecutor may have a few questions, and we'll figure out what we're going to do. Okay. All right, Ms. Feely.
Thank you, Your Honor. So the missed court date was September 19th. This was actually, I think, an error partially by my office because I did not get a file after her arraignment. And it just kind of got lost. And so I didn't ask, I filed into the case but then I never followed up with the DA about getting discovery or anything like that. And I didn't have her contact information for that reason. So that's kind of on my office. And then she had moved, but she did do a forwarding, but it took longer to get to her, unfortunately. But the moment she got it, she's been contacting everybody she knows to contact to make this right.
Okay. The system, the case management system shows Ms. Jackson that you're at an address on Dogwood Drive.
Yes, sir, 104 Drive.
New address or old address? That's the good address. Apartment H as in Henry?
Yes, sir.
Okay. So that's what's been updated, but I guess a few months ago, if we were sending notices out to you, it would have gone to a place you don't live at anymore?
Yes, at my terrace.
Okay. Who lives on Dogwood Drive with you?
My son.
Okay, just the two of you?
Yes, sir.
Okay. But sending mail there ought to get to you.
Yes.
All right. And then obviously we'll let Ms. Feely know. Does Ms. Feely have your phone number
Yes, I just got it. Right, wrote it down for
and
her.
your email address?
No, I need to write that down.
Please give her your email address as well. So she'll get that. She's got a phone number. Do you have Ms. Feely's phone number?
I need it.
Okay. And you need to get her email address too. So you guys complete that exchange. Was Ms. Jackson here for her plea and arraignment?
I believe so, yes.
Okay, I mean, if she wasn't here, it was because someone waived her appearance, but it sounds like the only thing that was missed was the final plea date. The way you described the administrative slip up in your office, Ms. Feely, it may have been that even if Ms. Jackson had shown up for final plea, you would have said, I don't know anything about this case.
Fortunately, that would have been.
Okay, but not because the DA's office was not getting you anything. It's you basically hadn't engaged with them because there was some paperwork breakdown in your office. Does that happen often?
It's the first time it's happened to me.
Okay.
So I'm hopefully not.
Okay. What is it that you need so we can move the case forward? We ought to reset it for another final plea.
Another final plea, I believe I did get, I haven't reviewed it, but I think I did get something discovery wise.
On the 14th, there was a certificate of discovery filed by Mr. Peoples that says you should have received through evidence.com a whole bunch of stuff.
I just confirmed it's there.
Okay, good. So you should look through that. I'll work with Ms. Nelson to get a new final plea date. We'll just add it to an existing final plea calendar. A month out? I don't want it to be too far out, but I don't want it to be so soon that you say, I'm still working through this.
I think a month is fine.
Okay. All right. Thank you, Ms. Clark, for being here. You were not late. We had Ms. Jackson here and Mr. Abate was here like, hey, let's try to knock this out while we're waiting on the jury. So I appreciate you showing up.
Yes, sir.
All right. Take care. Work hard on all your other cases.
Okay.
All right. Ms. Jackson, do you have any questions about what we've been discussing?
I just really don't know what's going on.
So you and Ms. Feely should talk. Now won't be the best time to do it because she's got one guy on trial and a guy who's charged with murder who may be pleading guilty, which doesn't mean your case is unimportant. It just means that Ms. Feely's mind is in a couple other places. She's going to contact you at the information you leave with her, phone number, email, etc. She's going to sit down with you, look over all the discovery, which would be police reports. It looks like there's some video. I don't know anything about your case, but there's video footage and audio footage. So that means people were interviewed, whether it was you or the alleged victim or witnesses. Ms. Feely needs to go through all that, and then she'll talk with you about it to say, this is a bad looking case. Here you are driving your car over the little kid who's the victim. Or it's a great looking case. Someone was shooting at you and you were just trying to get away. I'm making up scenarios, but Ms. Feely needs to look through the evidence so that she can help you think about the best way to move forward with the case. She'll then talk with the prosecutor to see if there's a way to work it out, if it's a case that ought to be worked out. I will see you in about a month at what's called a final plea, which is the last time you could enter a plea and have the ability to withdraw that plea if you were unhappy with the outcome. And I'm not saying that you need to enter a plea, but that's how most cases resolve. And that's what we would do on that day about a month out. So between now and then, those other things I've described, conversations with your lawyer, et cetera, those will take place. Does that make a little more sense?
Mhm.
Do you have more questions, not about the facts of your case, but about process? Okay. When did you move?
Like a couple of days ago, actually. I was going through Atlanta housing, so I was displaced for 30 days.
Okay, so you were out of the Abner Terrace, because we sent a notice a while ago. If you only moved a few days ago, you wouldn't have missed that notice, but you were displaced for a little while. Okay, for financial reasons, or there was a flood?
No, Atlanta housing, I went from a HUD program, subsidized housing, to Atlanta housing, so it's kind of like a better program.
Okay, good. What do you do for a living such that you wear a bright green vest and have an ID?
I work for Bosch Automotive Warehouse,
Okay, so that's what you wear in the warehouse? Where's the warehouse?
855 Kemp Creek Parkway,
Okay, well, good. How many days a week?
5
What hours?
to 1:30.
5 a.m. How does the little guy get to school?
He's big, he's 14.
Oh, he gets himself to school. Okay, all right, he's big. All right, don't tell him I said little guy. Mr. Abate, any objection from the state if I lift the bench warrant?
No, no objection at all.
Okay, I don't know that there's a bench warrant out there, but if there is, I'll get it vacated or whatever the right verb is. It wasn't showing up in the system. Oh, here it is. There's a set aside. I'll sign that set aside and you're good to go. Your commitment is staying in touch with Ms. Feely. Exactly. So get her information, give her yours, and you can get, I guess you're done for the day with Bosch. You can go see your kid. Okay.
Thank you.
All right. Thanks, Ms. Feely. Done? Okay. I'll have them call them and I'll see you back there. Do you want any other names from our weekend calendar?
I can,
If I can just give you a couple more.
let me just take a picture of the calendar. Is there a lot?
I'll just email, well, but the part that you would need to know, I'll send you the calendar and Ms. Walsh's list that says, gosh, we got an offer of 1,000 years on this one. Thanks. And we have a verdict in here, so if you want to go to Glanville and come back when you're done, we'll do that. And I'll email this to you. Thank you. Thank you for helping her out.
Thank you.
And I'm told we have a verdict. So we'll do that. I told Mr. Bate he could go to Glanville. We'll take care of this.
That's good. My day,
Is it a late day?
yeah.
Is it a late day?
Yeah. Parking day here first. Oh, you already know. Seven, yeah.
Thank you.
Yeah, since 12:30. Did you do your plate? No, I just.
How you doing?
How you doing, Judge? You good?
I'm all right.
Good. Sergeant Gordon, who's in the jury? Sergeant Palmer? Okay. Y'all,
Let me
so I
see.
got the verdict. You get verdict, okay.
Wow.
I saw your
Judge, you
email.
come here still at 7
That is so
last night?
creepy.
I read about it. I didn't see it happen, but it couldn't have been at a better time for the Braves. Sets up the winning run and boom. I mean, that's MVP stuff right there.
I think he's gonna get it.
I'm fascinated by the Betts versus Acuna race for MVP. Both those guys are so valuable for their teams.
Yeah, I think it's gonna be another Braves, Dodgers, NL.
CS, it ought to be. I mean, that's,
I'm concerned about the Phillies though.
yeah,
The Phillies, they're good.
they are, and they sort of put you to sleep and then, yeah,
So we'll see.
yeah.
Sergeant Gordon treated you though, Judge.
He's acting like a sergeant, showing up late, sleeping on the job.
I have a conflict with
Good.
it. I'll put him to the side.
You know, if you guys could just drive that guy back and forth to the jail each day, that would be good.
That'd be brave ticket from Miss Privilege. I know she has some brave tickets.
She's got a angle on those.
Yeah, she got brave tickets. Don't do that. Don't do Miss Privilege.
She's got. All right, Ms. Rivers, are you ready? Okay, we are back on the record in State versus Kamdem. Deputy Gordon tells me that the jury has reached a verdict. So my plan is to bring the 12 deliberating jurors back into court and receive that verdict. Ms. Hall, anything from the state before we do that?
Nothing from the state, Your Honor.
Okay, Ms. Feely, your client is back out here. Mr. Kamdem, are the headphones working?
They are, Your Honor.
Good. Anything more from the defense?
No, Your Honor.
All right, let's bring the jurors out, please.
All right, jurors. President of the County Court.
Thank you. Everyone can be seated. Ladies and gentlemen, it's my understanding that you all have reached a verdict. Is that correct?
Yes.
Are you the foreperson?
Yes.
If you could hand that verdict to Deputy Gordon, please. Sir. Sir, I'd ask you to stand now. You're the foreperson.
Yes.
And is the verdict that you have before you something that was unanimously entered by you and all your colleagues?
It was.
Have you signed the verdict form and dated it?
Yes.
All right. If you would please publish it, which is read it into the record.
Count 1, attempted rape. We find the defendant guilty. Count 2, improper sexual conduct. We find the defendant guilty. Count 3, elder abuse. We find the defendant guilty.
Thank you, sir. Deputy Gordon, if you would get that to Ms. Hall and then to Ms. Feely, please. Ms. Hall, do you have any objections to the form of the verdict?
No objection, Your Honor.
Ms. Feely?
No objection to the form.
Okay. Ms. Hall, anything else from the state before I release the jury?
Nothing further from the state.
Ms. Feely?
We'd ask they be polled.
Okay. Ladies and gentlemen, I'm going to ask each of you, and I go in numerical order of your original jury number, the same 3 questions. When I call your name, if you would please answer the 3 questions. First, juror 1, Dr. Hoff. Was the verdict that was just read into the record your verdict in the jury room?
Yes, Your Honor.
And is that something that you freely and voluntarily entered into?
Yes, Your Honor.
Is it still your verdict?
Yes, Your Honor.
Thank you. Juror number 3, Mr. Colbreth.
Yes.
Yes. Was the verdict you heard read in court your verdict in the jury room?
Yes, Your Honor.
Was that something you freely and voluntarily entered into?
Yes, Your Honor.
Is it still your verdict?
Yes, Your Honor.
Number 4, Mr. Rogers. Was the verdict read in court your verdict in the jury room?
Yes.
And was that something you freely and voluntarily entered into?
Yes.
Does it remain your verdict?
Yes.
Juror 6, Dr. Kuntz.
Yes, Your Honor.
Was the verdict read in court your verdict in the jury room?
Yes.
Is that a verdict you freely and voluntarily entered into?
Yes.
Is it still your verdict?
Yes.
Ms. Cooper,
Yes.
was the verdict you heard here in court your verdict back in the jury room?
Yes.
And did you freely and voluntarily enter into that verdict?
Yes.
Is it still your verdict?
Yes.
Ms. Harden, was the verdict read in court your verdict in the jury room?
Yes, Your Honor.
Did you freely and voluntarily enter into that verdict?
Yes, Your Honor.
Is it still your verdict?
Yes, Your Honor.
Thank you. Ms. Porbeck, was the verdict read in court your verdict in the jury room?
Yes, Your Honor.
Did you freely and voluntarily enter into that?
Yes, Your Honor.
Does it remain your verdict?
Yes, Your Honor.
Thank you. Mr. Wilson,
Yes, sir.
was the verdict read in court your verdict in the jury room?
Yes, sir.
Did you, sir, is fine. Did you freely and voluntarily enter into that?
Yes.
And is it still your verdict?
Yes.
Thank you. Ms. Chesney, was the verdict read in court your verdict in the jury room?
Yes, Your Honor.
Did you freely and voluntarily enter into that? Does it remain your verdict? Mr. Sislowitz, our foreperson, was the verdict you read in court your verdict in the jury room?
Yes, Your Honor.
Did you freely and voluntarily enter into that?
Yes, Your Honor.
And is that still your verdict?
Yes, Your Honor.
2 left. Ms. Crotty, was the verdict read in court your verdict back in the jury room? Did you freely and voluntarily enter into that?
Yes, Your Honor.
And is it still your verdict?
Yes, sir.
Okay, that leaves Mr. Walters. Was the verdict read in court your verdict in the jury room, sir?
Yes, Your Honor.
Did you freely and voluntarily enter into that? Does it remain your verdict? All right. Ladies and gentlemen, I want to thank you on behalf of the state, as well as the attorneys representing Mr. Kamdem and the citizens of Fulton County for your time. This was a very important matter for everyone involved, for Ms. Robinson and her family, for Mr. Kamdem, obviously. And it's something that we needed members of the community to resolve. It wasn't something that could resolve short of trial. Your commitment to the case meant that we have now achieved that resolution. So thank you for performing your civic duty and serving as jurors on this case. I'm going to ask you to go back with Deputy Gordon. I'll have the 2 alternates join you all. I'll have letters that say you've been here for all these days in case you need them for employers or roommates who've been wondering where you've been. And going to just offer a few additional thanks and then get you on your way. But again, thank you for your service.
All right, adjourned.
Ms. Hall, do you have what's your view as to, you all can be seated, when we should do sentencing?
Ms. Davis, ready to proceed with sentencing if you are, Your Honor.
Okay. Ms. Feely?
I can be. I actually use files on 5. I have Mr. Lewis's file with me right now.
Sure. We can do it today. That's really my question is, do we do it today or do I bring Mr. Kamdem back at another time? I'm open to doing it now, meaning this afternoon, whether you want to finish up with Mr. Lewis and then we turn back to this, or just literally go get your file. I'm open to whatever. It sounds like Ms. Hall is ready to go forward today. And I know that we have Ms. Jefferson here, and so it may make sense to do that while she's here.
Sure, and if the court's planning on talking to the jury, by the time you're done with that, I'll have to file.
Okay, I'll do that. I'll go get the jury out of here, chat with them briefly. I'll actually let them know sentencing is what's going to follow, and some may choose to stay here. I'll have them be in the jury box for that. And then we'll get back here and do sentencing. Okay? Thanks.
I still say it in a minute, because even if it's on USB already, I don't have a. Yeah.
So nice.
Sorry?
It looked nice, doesn't it?
Marilyn, leave. She was on the phone. I was just down there, but she was talking to somebody I don't know.
I'm sleeping. We ain't moving.
No, I'm just, I might as well, I'm just standing by. Cause ain't no point in me just leaving. I gotta sleep anyway.
I mean, rather than we have a situation where that's put some.
Don't try.
I mean, they outside, why you go out and talk? That's right. They hang around that.
Oh, all right.
No. Might have come back.
Oh, I have the key. Remember, I was in a different courtroom, remember?
Yeah.
So that key's gone. I'm coming to get my gun. Grab it somewhere.
Got it, thank you. It is cold in here, right?
You supposed to be prepared. I told her
Blanket.
a big jacket, a scarf and all that. She said, I'll be all right. Good morning.
I said I'd wear a snuggie if I remember right.
Right.
All right, Ms. Rivers, are you ready? Okay, I guess we need to get Mr. Kamdem out here. Did you get your file? Right. Do you have a sense, Ms. Feely, from Ms. Primovic, what we're doing with Mr. Lewis?
She's talking with them now.
Okay,
so-
they're still conversing. Okay, is that a good dynamic or do we need you back there?
She met with him yesterday for me. so-
Okay, so it's not a foreign face to him.
I think there's, could be productive talks.
Okay.
Without me back there.
Great. How are you?
I just want to make sure that do you have signed indictments yet? Do you understand? I need to file them.
It's it would be with the evidence. I don't know what Gordon did with that. If he returned, he didn't bring it out yet? Okay. We need the indictment. Yeah, so it should be with that stuff. So we just need to make sure he grabs that. I know he went in there with all their phones and stuff, and so maybe his routine is then he puts the evidence in there. That would have the indictment.
Okay, I just want to make sure she said, what do they
Okay.
need to do? Okay, thank you.
Two things. One, we need Mr. Kamdem. And two, we make sure you get the evidence, in particular, the indictment.
Yes.
Okay, it's in Ms. Rivers' office. Okay, great. Thank you. So then we need Mr. Kamdem. They want to come out. Okay. You just bring them to the jury box? All of them? Some of them. Okay. He's just goofing around right there? Oh, with Mr. Lewis.
There's a lot.
Ms. Rivers, are you ready? All right, we're going back on the record in State versus Kamdem. The jury has handed down its verdict, and Mr. Kamdem has been found guilty of all 3 counts of the indictment. We're going to turn to sentencing now. Ms. Hall or Ms. Marsh, I'm ready to hear from you and anyone you may have who wants to be heard in connection with victim impact.
Thank you, Your Honor. Ms. Jefferson is in the courtroom, but our victim witness advocate, Ms. Latika Montgomery, will read her impact statement.
Okay. Do you want to start with that and then get into what your recommendation is?
Yes, Your Honor.
Okay. Ms. Montgomery?
Good afternoon, Judge. How are you?
I'm okay. How are you?
Good, thanks. Need me to spell my name for the record?
Especially the first name.
It's actually easy. It's the way it sounds. Latika Montgomery, Lateeka, Montgomery, Montgomery. So the statement is from Belinda Jefferson. There is a rule that dates back to biblical times. What is done in the dark eventually comes to light. This rule does not respect race, gender, sexual orientation, and most importantly, it also does not respect status. Edward Kamdem is a so-called esteemed professor with the fancy accent and PhD letters behind his name. Behind his name must be replaced with those letters of liar, fake, predator, and now inmate. He preyed upon and victimized a sweet and innocent woman, a woman who is loved by many, most of all by me, a woman whose mind was unfortunately ravaged by one of the cruelest diseases known to mankind, one that ironically also has no respect for status, Alzheimer's. She could not consent and could only lay there while he, who should have cared for her, respected her, and acted in her best interest, had his demented way with her by raping her. She was unable to communicate her wishes. He took advantage of her. He raped her. So Edward is soon to go to prison, and that also has no respect for status. And the stories that I have heard indicate members of what will be his new community may very well wish to have their way with you. Only this time, you are not sweet and innocent. In the fact, even before that time comes, I want him to think of my sweet, innocent, defenseless Flora. I pray that that he's constantly reminded as he lays awake of Flora. Perhaps this will bring me some level of solace when I close my eyes and I see him on top of her, my innocent and helpless love. I want to thank the jury and the judge and the attorneys for their time, effort, and humanity. That's it.
Thank you. Thank you, Ms. Jefferson. You're blocked right now. Ms. Hall, let's start with what you think the sentencing ranges are for the 3 counts, and then I'm happy to hear what your recommendation is and anything else you want to weave into that.
Yes, Your Honor. For count 1, the sentence range is 1 to 30 years. For count 2, 12 months to serve, and count 3 is 1 to 20 to serve.
Okay. And what do you know? I think we do have someone from pretrial, so I'll ask Ms. Hardy in a minute. What do you know about Mr. Kamdem's criminal history, if any?
It's my understanding he doesn't have a criminal history.
Okay. What's your recommendation?
The state's recommendation, Your Honor, for count 1 is 30 years to serve. For count 2, 12 months to serve, and for count 3, 20 years to serve. I won't repeat any of the evidence we've all said here all week and heard it, and the state is in a position to feel as though this was a horrific act that he did to Ms. Robinson, and so those are our recommendations, Your Honor.
Are those to run concurrently or consecutively?
My apologies, to run consecutive.
So your recommendation is effectively a 51-year sentence.
Yes, Your Honor.
All right. If Mr. Kamdem is given a sentence that includes some probation and is not straight custodial time, do you have any conditions of probation that you'd want to see?
Condition 1, that he registers as a sex offender. Not be able to work at any type of assisted living facility, or with any elderly person. And obviously, stay away from no contact with our victim or the victim's wife.
Okay, thank you. Anything else?
Nothing further from the state.
All right. Good afternoon, Ms. Hardy. Do you have any criminal history information on Mr. Kamdem? I don't know that you were necessarily given his case number.
If you give me his case number, I can look it up real quick.
That'd be great. Thank you. It is 22 SC 183536. And while you're looking it up, I'll pivot to Ms. Feely to hear what she has to say, and then I'll come back to you, Ms. Hardy. Thank you. Ms. Feely, let's start with just the technical piece about what you think the ranges are. And then, of course, I want to hear anything substantive you have to say, and I'll see if Mr. Kamdem has any allocution that he wants to do.
I had that same thing with Tennessee range on all counts, so.
Okay, so you're in agreement, 1 to 30, 1 day to 12 months, and then 1 to 20. Okay.
So as the court heard over the course of this trial, Mr. Kamdem is 74 years old. He is an immigrant from Cameroon. He migrated to Canada first, completed his degrees, then moved to the Atlanta area where he was a professor of French at Kennesaw State until his legal status expired after decades of being here. And he applied for asylum and was denied. And so he had enough work documentation to be able to work an hourly wage job for 9 years, which was the one in question. But the most striking thing about Mr. Kamdem's situation is his lack of any criminal history at all. No parking tickets that are on his record that we can tell. So for that reason alone, I think consecutive maxes is not appropriate here. I would also point out that the offer of 20 to serve before trial is likely not meaningfully different from what the court is going to impose. I don't think he was going to get out either way, which is what made this particularly challenging. The other piece is that any plea anyway, if it was something that he would have likely survived, he would have made him deportable. And I don't know that our diplomatic ties with Cameroon are such that we could deport there, but certainly with this type of charge, my information is that he most likely would have been. And I also wanted to put on the record, he's been continuously in custody since his arrest on September 8th of 2021. It doesn't appear that way from the records that we have because he left Rice Street to go into immigration custody the whole time.
So it's more, the system right now is saying 501 days, which is a big number, but it's longer than that because there's the piece of time when Mr. Kamdem was in, we'll call it federal custody.
And not that that practically makes a difference either, but I just wanted to make sure that he gets credit for all of the time that he's done since September 8th of 2021.
So it's 2 years and a few weeks. Okay.
Thank you.
All right. Mr. Kamdem, you have a right to what we call allocute, which would be to say anything you want or nothing at all. It's important that I give you that opportunity if there is anything you want to say. But like I said, you're not required to say anything at all. But if you're going to say something, now is the time for you to do that.
No, Your Honor.
Okay.
Thank you.
Ms. Hardy, did we give you enough time?
Yes, Your Honor. The only thing that's showing on his criminal history is the matter that's before the court right now.
Okay, thank you. Mr. Kamdem.
Yes, Your
Honor. I'm not surprised by the tenor of the victim impact statement that we received from Ms. Jefferson. It was angry. I think it was justifiably so. As I get older, I see how circular life is. And as my parents get into their twilight years, I am seeing more and more how they are going to, in some ways, be like my children in terms of the care they will need and the trust that I will need to put in those who are caring for them, because they are becoming less able to advocate for themselves, less able to defend themselves. And I don't mean against an attack, although that is applicable in this situation, but just to push back in a situation that seems to them unfair or unsafe. And more in our society, as people live longer, we are having to entrust loved ones into the hands, into the care of effectively strangers, caregivers, much like a child might go to daycare, we are putting our parents and our loved ones in assisted living facilities with this presumption that they'll be safe there, with this presumption or assumption, not always well placed apparently, that in places like that, they'll be safe from the kind of harm that was inflicted on Ms. Robinson here. There's the direct harm to Ms. Robinson. There's the betrayal of trust that Ms. Jefferson and others would put in a place like the Mann House. And I'm not blaming the Mann House directly here, but it's an employee of that brought this harm to Ms. Robinson. And really the tragedy here is that we really never got to hear from her, how this has affected her and how she's processing and struggling with it all. It's inexcusable. This was a truly defenseless individual who you knew could never talk about what happened. It's the perfect, in an awful sense, it's the perfect victim. And I hope it was your only victim, but we'll never know that. Mr. Kamdem, I am going to sentence you on count 1 to 25 years to serve. Count 2 will be 12 months to serve. That'll run concurrently with count 1. Count 3 will be 20 years to serve. That'll run concurrently with count 1 for a total sentence of 25 years in custody. You will get credit for all the time the custodian deems you should get credit for. At a minimum, that will be 501 days. It's not my decision whether you get credit for the time you were in federal custody, but I will note on the record that you have been in continuous custody since you were arrested on these charges, and all the time that you have been in custody, it has been as a consequence of these charges. And so it strikes me that you ought to get credit for all that time, but higher courts have told trial judges recently, don't make those decisions for the Department of Corrections. Mr. Kamdem, I need to give you some information about your appellate rights. Your lawyers will explain this more clearly, but I'll try to explain it clearly while I'm here with you. You have the right to seek 2 forms of appellate relief now. Number 1, you could seek a new trial, and Ms. Feely would file on your behalf what we call a motion for new trial. And that's an attempt to do this process all over again because of some mistake I made, or maybe the prosecutor made, or maybe your lawyer made. It's a motion for new trial. And if I grant it, we do this trial all over again. If I deny it, you still have an appeal to the Court of Appeals. So that's option 1. Option 2 is to file a direct appeal right away to the Court of Appeals to make all those same types of arguments. You can do both, but you'd need to do motion for new trial first if you want to do both. I'm going to ask you and Ms. Feely and Ms. Pinto to talk about what you want to do. They'll give you their thoughts on that. And they will either, if you ask them to, file that initial motion for new trial, and they're going to step off your case because one of the arguments may be they made a mistake on your behalf, and you need a different lawyer who will be appointed at no cost to you to make that argument. Or you may decide, nope, I don't want to deal with McBurney anymore. I want to go straight to the Court of Appeals, and you've got that right. You have a clock running, and it'll be 30 days from today that you have to file that motion for new trial or that notice of appeal. So you're going to want to talk with these 2 lawyers today and give them your instructions. And if you tell them to file one of those 2 things, they'll do that today or tomorrow in plenty of time. You have a second channel of appeal that's called habeas corpus. And that really doesn't kick in until you've exhausted all your appeals, but I still need to tell you about them now. You have 4 years from the date that your conviction is final, meaning you've exhausted all your appeals. You have 4 years after that date to file a habeas challenge, which is a civil lawsuit where you'd make some of the same arguments. You will not get a lawyer for that unless you can afford a lawyer for that. But you'll always have a lawyer helping you with the motion for new trial or your direct appeal. Do you understand on the basic level the rights that I just shared with you?
I do, Your Honor.
Okay. Well, I'm going to have your 2 lawyers talk to you about next steps and they will follow your directions on that. Ms. Hall, anything in addition on behalf of Ms. Robinson or on behalf of the state?
Nothing further from the state or from this process.
All right, Ms. Marsh and Ms. Hall, thank you for your work. Ms. Feely, Ms. Pinto, anything else on behalf of Mr. Kamdem? All right, please do confer with him. And if you need to file a placeholder of either of those, just in the next few days, get that in there and I'll take it from there. Okay, thank you. Is he not going back now?
Yes, I need to talk to him before you. leave,
Okay, but he doesn't need the headset for that. Okay, so if you'll take the headset off. You need me to go away? Oh, no.
Yeah, he
Yeah.
can go back.
Pardon me? They were happy to give feedback. I don't know that they're staying now, but you should go, you can go check. Did any of them gonna stay or they just left? Okay, well, they want people to talk louder.
Yeah, I guess.
I think just the ones, just the what you wrote. Yeah.
Good.
Ms. Primovic, how are we doing with Mr. Lewis?
He's doing well, Your Honor.
I'm glad he's doing well.
Want to go back in?
So just time frame wise, I have to get on a pattern jury instruction Zoom call at 4:30. So if we're gonna do something today, it would be in the next few minutes. Otherwise, we'd just come up with a plan B. Okay, thanks. Ms. Hall, I did tell the jurors, just because we're doing sentencing right away and then they were going to want to leave given the time. Any that were interested in providing feedback or just interacting with you all to call Ms. Hansberry and leave their name and number. And that would be a signal that you all could reach out to them. So if I hear back from any of the jurors, I'll certainly let you know and then you can chat with them that way. I know feedback is valuable. I told them as much. I said, look, I liked getting it as well. That's not how this one flowed.
Well, thank you.
Thank you, guys.
You know. So next time.
Until next time, the consolidated criminal calendar came out today. I don't think any of your cases are on it. You had one, but it just pled, the one in front of Judge Eaton. Yeah, I don't know if you have another one. Some of them were retreads from last month. From this courtroom, it's, what did I put on there? Jerry Peck, which is Ms. Charles, and the immunity motion we just had, which is Mr. Abate. So those are the McBurney one, but I don't know what else is on there. Ms. McCauley's got the calendar, so she can get it to you guys.
Check my email.
You too. Oh, let me send that to.
I'll be right back.
So the jurors were appropriately frustrated with Detective Smith for having whatever happened with those videos. And when I told them about the one with the dining room, like, what? But they understood why they didn't get to see it either. Like, wait, so when did Miss Feely get it? Like, the middle of trial? They said, that's why he's not a detective anymore. I said, I don't know if that's it specifically.
I'm gonna go down to 5 and drop some stuff off, but I'll be in the building and so I can come back up. If Ms. Burns needs me to.
Okay, she's handling this for now?
Sounds like she is.
Okay. This seemed, I don't know anything about the facts and we shouldn't talk about them without Abate here, but this seems like a pretty open-ended way to sort this out. But it's his decision, not yours or Miss Primovic's. All right.
Thank you.
But if I bug her in a few minutes, she says, yes, it's a go, we don't need to find you, or she'll find you.
And she has her phone, I'm pretty sure, so she'll text me.
Okay,
and
all
come back.
right. Hopefully, is Abate just down in Glanville?
Yeah, it's obviously.
Okay.
Oh, shoot.
She heard you were coming, so she busted out of here.
Thank you, Judge.
Thank you. You were hopefully good emotional support for Mr. Kamdem. And you helped technically with some things and maybe you learned some stuff from watching. Miss Feely did great with what she had.
I definitely learned. Hopefully I'll be in here again in a more active role at some
Good.
time.
Good. It may be a less depressing case.
Hopefully. Have a good day.
All right, take care. So everyone's been leaving you. So Miss Feely just ran off. Miss Pinto's leaving now. Are you good?
Yeah, we just need Adam.
Okay.
I'm good. She's fried.
Okay. You're fried. Bye-bye.
She's fried.
Okay.
I'll get Adam.
Is he just with Judge Glanville? Is he just down with Judge Glanville? Yeah.
I don't know, but we're ready for a pleading.
Okay, well then let's get Mr. Abadi. I'm ready too. Okay. Okay, you call and Deputy Gordon will run or sort of move. Funny thinking of him playing football.
that circle of life, some of that circle of life. You made, I think about it, like my kids, you know, I can take care of myself, but I saw how my father, man, my father was big and strong. When he came, I had to lift him up out of bed, but you made me reflect. I'm like, yeah. I tell them, I said, I'm trying to do for you so you can help me. But yeah, that was good. That was a good one. That was a good one. Made me reflect. Like I was like, God,
Well, we just see it more. I mean, I guess you've already gone through it with your father. I'm starting to go through it with my folks. Like when my parents come to town, my dad's like, I'm gonna drive. Like, you're not, just get in, man. You're good. Yeah, let me drive. Plus, I don't want to drive with you. You're gonna kill us all. Yeah.
they didn't do it.
Yeah.
They don't see themselves in the same light.
Yeah. And it's the same. So my oldest is just starting to drive. I'm like, you know what? Let me drive. I'll drive. It's good. You'll get to playing driving, but let's just all get there and not run the risk of you as a rookie driver. Like, whoa.
Get down the way.
Yeah, Adam is washing his hands.
Hey, go ahead.
Washing its hands.
Not that one.
Not that one.
Yeah, you said that.
Okay. Well, I'll just sit down.
Yeah, stand.
What have you been up to recently? Any trials?
Yeah, I did one in Whitaker last week or the week before. So aggravated assault, and then sat with Lacey on the one with Judge Ingram.
Oh, the one that was in here. Yeah.
Did a little BHTC this morning.
All right.
Yeah, I gotta keep it, you know.
Good. Keeping your finger in every pot.
Right, and nowhere at the same time.
An aggravated assault went to trial. Was it like a one-day trial?
It was.
Or it could have been a murder, but someone didn't die.
Right. It was interesting. It was apprehension, ag assault with a machete, a car, and then the video was fantastic. It was amazing.
Any video with a machete would be good.
Offer was 5 and he got 8, so.
All right.
Good job. What would you like me to do?
Right there is fine with camera and microphone. We can make it work.
What's your laptop, Your Honor?
It's associated, it's ITs. If you just put it right there, we'll return it to them.
Yeah, I'm gonna be sitting right next to you.
All right, we've got Ms. Hardy, which is great. Let me just get Ms. Rivers and we can take the plea.
I'll turn.
It's one I've written on.
I might have. Deidre usually has one.
And she signs for us.
Right, correct. Taking a plea, you get.
All 3 will be reduced to all. 2 to 3 will vacate.
Okay.
So you know, sometimes we do all of the murder.
Great.
How much can I give you?
Okay.
That way.
Sounds good. Thank you.
Well.
Oh, he said, he said, he bring the down. I'll tell you what he told me. You go tell him. So you go tell him.
I thought you were.
You know, this was 2 years ago. So it's happened.
I am.
To be
You tell him, you have business, make a phone call. No, so where you
All right, Ms. Rivers, are you ready? Let's get on the record with Mr. Lewis. It is 22 SC 183-910. Mr. Lewis is charged with murder, felony murder, and a few other offenses. We have a non-negotiated plea. There is a negotiated component to it in that, as I understand it, and Mr. Abate will get all this on the record at the appropriate time, but the state is willing to reduce murder to voluntary manslaughter. And then the state is also proceeding with the possession of a firearm during commission of a felony count and the possession of firearm by a convicted felon. The state's recommendation will be 20 to serve 7, balance probated, credit for time served. And Ms. Primovic, who is representing Mr. Lewis as co-counsel to Ms. Feely, will be free to advocate for whatever sentence she and her client deem reasonable in light of the facts, as I'll hear about them from Mr. Abate and from Ms. Primovic. Does that fairly summarize where we were before we took the break, Mr. Abate?
Yes, Your Honor.
All right. Mr. Lewis, are you prepared to go forward at this time?
Yes, Your Honor.
Okay, I'm gonna need you to speak up, but it'll be better because we just moved the microphone towards you. In a moment, Mr. Abate is gonna put you under oath. When you're under oath, you'll need to answer his questions and mine truthfully and completely. If you have any questions at any point, let me know. If they're ones that are for Ms. Primovic, you all can speak privately. If they're procedural that I could help with, then I'll try to answer them, okay? Because you'll always need to answer out loud. Nodding isn't something she can take down.
Okay.
Great. Mr. Abate, when you're ready.
Mr. Lewis, if you'll please raise your right hand. Do you solemnly swear and affirm that the testimony that you're about to give in the matter pending before this court will be the truth, the whole truth, and nothing but the truth, sir?
Okay. Yes, sir.
Okay, you can put your hand down. Thank you. Could you state your true, correct, and legal name for the record?
Jamel M. Lewis.
And Mr. Lewis, are you at this time taking under the influence of any alcohol, drugs, or medicine?
No.
Is there any medication that you take daily or that you normally take on a regular basis that you haven't taken today that would affect your ability to understand why you're here today?
No.
And Mr. Lewis, how old are you and how far have you gone in school?
I'm 43. I went to the 9th grade.
The 9th grade? Okay.
Do you have your GED?
Yes, sir.
Where did you get your GED?
I have my GED in a correctional facility in 2007.
Okay.
And Mr. Lewis, are you able to read, write, and understand the English language?
Yes,
Okay, and do you understand that you were charged with the following offenses in indictment number 22 SC 183910? Count 1, murder, counts 2 and 3 are both felony murder charges. Count 4, aggravated assault with a deadly weapon. Count 5, possession of a firearm in the commission of a felony. And count 6, possession of a firearm by convicted felon.
yes,
And do you understand, sir, that you have the right to plead either guilty or not guilty to these charges? And if you pled not guilty or remain silent, you may receive a jury trial.
yes,
And has Ms. Primovic as well as Ms. Feely had an opportunity to go over with you the rights that you would be waiving with this guilty plea? Did they talk to you about what you're?
Oh, your rights, maybe whenever you're, the jury trial, subpoena, have those rights.
yes.
And do you have any questions about the rights they may have gone over, if they may have showed you a form or anything of that nature through all your conversations with both Ms. Feely and Ms. Primovic?
Okay.
Do you have any questions?
Oh, no.
And have you had enough time to speak with both of your lawyers about all the facts and circumstances known to you regarding the charges and the facts of this case and your potential offenses?
Yes,
And do you need any additional time to discuss any matters with Ms. Primovic at this time?
no, sir.
And are you satisfied with the services that both Ms. Primovic and Ms. Feely have provided, sir?
Yes, sir.
And Ms. Primovic, do you waive formal reading of the indictment?
So wait.
And do you also waive any and all defects in the indictment, including any with respect to your client's name for the purposes of this plea?
Yes, sir, we do.
And Mr. Lewis, has Ms. Primovic advised you of the minimum and maximum sentence for each of the charges that you're pleading guilty to?
Yes, sir. Yes, yes.
Okay, and did Ms. Primovic advise you as counts 1, 2, and 3 are all going to be reduced from murder and felony murder to voluntary manslaughter? Did she advise that the minimum is 1 year, the maximum is 20 years for the voluntary manslaughter counts?
Yes,
And did she advise that for aggravated assault with a deadly weapon, the minimum is 1 year, the maximum is 20 years?
yes,
But for the purposes of this plea and the record, aggravated assault would actually merge with count 1 voluntary manslaughter, so you wouldn't be sentenced on that count.
okay,
And did she advise that for possession of a firearm and the commission of a felony, that the sentence that must be received is 5 years, and it must be consecutive to any sentence that you receive for, in this instance, count 1, but that sentence may be suspended, probated, or time served in prison.
yes, sir. We went over that. Yes,
And then lastly, count 6, possession of a firearm by a convicted felon. And then Ms. Primovic advised you that the minimum is 1 year, and the maximum is 10 years.
yes.
Do you have any questions about the minimum and maximum for any of the charges that you're pleading guilty to, sir?
No, sir.
And Mr. Lewis, do you understand this is a non-negotiated plea of guilty? Which means that the state will recommend a sentence to the court, and as you've heard, a global sentence of 20 years to serve 7 years in custody with the balance probated. But your counsel, Ms. Primovic, also has the opportunity to make a recommendation as she sees fit to the court, but the court doesn't have to follow either recommendation and can sentence you to the maximum for the charges you're pleading guilty and run them one after another or consecutive.
Yes,
And Mr. Lewis, you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including the federal courts. Let me read it again, I'm sorry, I know I talked fast. Do you understand that by pleading guilty here today, this plea can be used to enhance sentencing on other convictions? So when you get out of prison, if you commit another offense, and you were sentenced on that new offense later down the road, that your plea here today.
yeah, I understand. I got you.
I'm gonna read it again.
Okay.
Do you understand that this plea may be used to enhance sentencing on other convictions here in this jurisdiction, Fulton County, as well as in other jurisdictions, for example, Ohio, where you're from, and the federal courts?
Yes,
And you understand that if you're not a United States citizen, a guilty plea will affect your immigration status and will result in deportation regardless of any advice given to you by your attorney or anyone else.
Yes.
You understand that you waive any and all defenses by entering a plea of guilty here today.
Yes.
And do you understand that by pleading guilty, you're giving up the following rights: the right to trial by jury, the right to remain silent and to not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or court appointed if you were unable to afford an attorney at the trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and to compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt by the state of Georgia, and the right to appeal if convicted of these charges after trial. Do you understand that you're waiving or giving up all of those rights by pleading guilty here today?
Yes, sir.
And Mr. Lewis, has anyone forced, threatened, or promised you anything to get you to enter a guilty plea here today?
No, sir.
And is it your decision to waive these rights and enter a guilty plea because you're in fact guilty of the charges that you are pleading guilty to, reduced counts?
Yes, sir.
And Mr. Lewis, how do you plead to the charges in indictment number 22 SC 183910, count 1, which is reduced from murder to voluntary manslaughter, OCGA 165-2?
Guilty.
Okay. And how do you plead also to counts 2 and 3, which are both felony murder charges, being reduced to voluntary manslaughter, again, OCGA 16-5-2?
Guilty.
And how do you plead to, well, and I apologize, so the state is gonna have to amend my recommendation. So what I'm gonna do is I'm gonna be null pros on count 3, because actually voluntary manslaughter is not a lesser included offense of felony murder predicated on possession of a firearm by convicted felon. So that the sentence is legal. I'm gonna null pros count 3.
Okay. So 3 is just being dismissed. It's going to have the same, overall, the same recommendation from the state. But he needed to do that to move forward with what he had promised.
Thank you.
Good catch.
And as to count 4, Mr. Lewis aggravated assault with a deadly weapon. How do you plead to that count?
Guilty.
And count 5, possession of a firearm during the commission of a felony. How do you plead, Mr. Lewis, to count 5?
Guilty.
And lastly, count 6, how do you plead to possession of a firearm by a convicted felon, sir?
Guilty.
And Mr. Lewis, do you understand, or is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, sir.
And do you understand that you may only have a limited right to appeal this guilty plea conviction, sir?
Yes, sir.
And lastly, do you understand that you have only 4 years from today for a felony charge to file what's called a habeas corpus petition challenging this guilty plea?
Yes, sir.
And have you had time to go over what a habeas corpus petition is with both of your counsel, Ms. Feely, as well as Ms. Primitive before this plea?
I know I didn't, but I'm going to make sure that he does now. Just, I'm sure Miss Feely did, but just to make sure.
Yes.
You got 4 years to say something.
Yes, sir.
Okay, so Mr. Lewis, after speaking with Ms. Primitive, do you understand that you only have 4 years from today for a felony charge to file a habeas corpus petition challenging this guilty plea?
Yes, sir.
Okay, thank you, sir. Your Honor, had the state proceeded to trial, the state would have proved beyond a reasonable doubt that on September 29th, 2021, around 10:32 p.m., Mr. Lewis, the defendant, and the victim in this case, Mr. Jamal Ali Riley, were at 1395 BD, which is BEATIE Avenue in Northwest Atlanta, Georgia, here in Fulton County, Your Honor. They were at Mr. Lewis's house where Mr. Lewis and a couple of their mutual friends, Mr. Reynolds and Mr. Christian Friday, and some other people were playing cards at that home. And Mr. Lewis actually lived at that home, and Mr. Riley, the victim in this case, had previously resided in that home with Mr. Lewis. But about 2 months prior, Mr. Lewis, who is the owner of the home, informally evicted Mr. Riley, or asked him to leave, rejected him from his home. It was done without the assistance of the courts, but he was asked to leave, and he did. After Mr. Riley was asked or told to leave, about 2 months prior to the homicide, or right after he was evicted, he did actually break back into the home that is owned by Mr. Lewis and that Mr. Riley formerly resided in. When he did that, he was actually caught by the defendant. He was,
Bless you.
Defendant was home. Because of Mr. Riley breaking into his home, there was a fisticuffs fight between the victim and the defendant in this case, resulting in actually Mr. Lewis receiving a swollen eye or a black eye. Things kind of calmed down for a little while after that time, but on September 29th, 2021, Mr. Riley again showed up to the 1395 BD Avenue home. And when he did, he showed up in an attempt to purchase cigarettes from Mr. Lewis. Mr. Lewis actually sold cigarettes, is my understanding from speaking with the witnesses and the detective through his investigation. He actually sold cigarettes in the neighborhood to people around the area. And that night, Mr. Riley showed up asking to purchase cigarettes. Mr. Lewis answered the door and granted him entry into the home he had been previously kicked out of. But after Mr. Riley had purchased cigarettes and after some time had passed, kind of a verbal argument ensued in which after that point, Mr. Lewis then asked Mr. Riley to leave the home. Mr. Riley did not leave the home when asked. And again, the verbal argument escalated. And during the escalation of the argument, Mr. Lewis pulled out his firearm and fired at Mr. Riley, striking him 3 times, Your Honor. And upon the shooting, many of the witnesses, as the verbal argument had escalated, had kind of scattered or fled. And after the shooting, everybody fled, including the defendant. Mr. Riley remained inside the home where he bled out and passed away or died. And a 911 call was eventually placed through an anonymous or unidentified individual who, through the recording, is a male. And the male called 911 to let them know that another male who had received gunshot wounds and was likely deceased could be found at the BD Avenue address. This call came several hours after the shooting, around 3:30 in the morning. Investigators and officers responded to the scene and began their investigation here with the Atlanta Police Department. As they began to investigate and canvass, they were able to locate a neighbor who had a Ring doorbell who was able to capture all the gunshots. Just the sound of the gunshots, you couldn't see anything, you couldn't tell who was shooting, things of that nature. So at that time, that was all the evidence and the leads that the investigators had. But within the days that followed, investigator Gordon Payne did receive a call from Mayshawn Reynolds, MESHAWN, and he indicated that he was at the house and described what I just described as to everyone playing cards, Mr. Riley coming over to purchase cigarettes, and then a verbal argument ensued because Mr. Riley refused to leave, which led to gunshots being fired. They were able to locate Christian Friday, who was also there playing cards. His nickname was Stone. He explained to the detective the very same thing. They were both actually, Mr. Reynolds and Mr. Friday, were able to explain how Mr. Riley had been kicked out of the home a couple of months prior. That Mr. Riley had actually broken back into the home, which caused the animosity to increase between both the defendant and the victim, and that the victim did show up again unexpectedly that night, on September 29th, as cards were being played, and, again, refused, to leave after being asked, which led to, everyone hearing gunshots. What both, Mr. Friday and, Mr. Reynolds will testify to is that they didn't actually physically see, who shot the gun, that Mr. Lewis, they actually shot Mr. Riley. They would be able to testify they saw Mr. Lewis pull out a firearm, and then that's when they immediately turned and fled and ran.
But who else would have shot it? Was there some evidence that Mr. Riley had a gun too?
So nobody saw Mr. Riley there with a firearm. What, in all candor to the court, when Mr. Riley was located, at the home later, after the police did, respond, he did, have a holster in his waistband or near his stomach area. There was no gun, that was found on scene. There were the ballistics were picked up, and tested by, the Atlanta Police Department's crime lab, as well as a private examiner, Mr. J. Jarvis, who would indicate that the 3 shell casings that they found, were all consistent with being fired from the same firearm, which was a 9mm, and then the projectiles that were removed from the victim, in this case, Mr. Riley, during autopsy, also the testimony would have been they all came from the same firearm as well.
Okay.
No firearm was located on scene, and when the police arrived, the only thing they found were ballistic evidence in Mr. Riley. Everyone, it was a dark house, and everyone had fled.
Were the bullet wounds from the coroner described as entering from the front, or was he shot in the back?
All wounds, entrance wounds from the front.
Okay.
So all consistent with a verbal argument ensuing between both the defendant and the victim face to face, and in candor to the court, the witnesses have described that Mr. Riley did not back down. Mr. Riley was significantly younger, actually, than Mr. Lewis. He was in his mid-20s. He was 24 years old, or right shy, I think 24.
Okay.
And what the testimony then would be from Detective Payne, Mr. Lewis was apprehended much later in June of 2022 in Ohio, where the evidence would have been he fled. He in fact had spoken to Mr. Reynolds, who was aware that he had fled to, or he had left the home and ended up in Ohio. And that was on June 2nd of 2022. And since his arrest, Mr. Lewis has been in continuous custody. When he was transported from Ohio to Atlanta, he was Mirandized, but exercised his right to silence and requested counsel. So no custodial interview occurred upon his arrest. That's what the evidence, or what the state would have been able to prove beyond a reasonable doubt as it relates to this case and the defendant, Mr. Lewis. And I'd add, and again, candor to the court, the evidence would have likely been that Mr. Riley was known as kind of the neighborhood bully, I guess, for lack of better words. All of that is mitigating circumstances that led to the reason for the reduction of the charges, as well as the recommendation from the state to the court, and the recommendation being that it would cap our a recommendation to serve in prison no more than 7 years drawing.
Okay.
I will express to the court that the victim's mother, her name is Bonnie Cole, she has been present in court on a number of occasions or on Zoom. I have spoken to her as well as previous attorneys for the state, specifically Ms. Larissa Olivier. She has expressed extreme dissatisfaction with the recommendation. I have made several phone calls to her in the last 2 weeks, had no success in reaching her, but I have left voicemails. So she is not present, but the state did notify her through leaving several voicemails that a plea was hopefully to ensue within the next coming weeks. I actually called her last night and left her a similar message, and have yet to receive a call back. But we've expressed to her what the offer was and why and the circumstances for the state's recommendation, and she vehemently does not agree, and understandably so.
Sure.
But looking at the totality of the circumstances, the state believes this would be a fairest resolution based on all the facts and circumstances, as well as the defendant's criminal history. He does have 3 prior felony convictions, all from Ohio. The first being in October of 1999, where he pled to possession of the controlled substance, and he pled guilty in 2000 and looks like 3, Your Honor, to trafficking in a controlled substance as well. And then lastly, in 2007, he pled guilty to a burglary offense and a domestic violence offense, all occurring in the state of Ohio. Your Honor, he did have a aggravated battery charge out of Fulton County in 2017, but it was looks like it had been reduced under case number 18 SC 162399 to disorderly conduct. And I bring that to the court's attention and to the defendant's attention. I know I had listened to some of Mr. Lewis's jail recordings, and I think he believed he had been lied to by his attorney at the time, I believe was a public defender, as well as the state, that he had pled guilty to an aggravated battery. And I want to make clear, Mr. Lewis, into the record, that his plea was to a disorderly conduct.
A misdemeanor.
Yes.
Okay.
So nothing further from the state at this time.
All right. Thank you. Ms. Hardy, I want to get you on your way. Can you share if you have any additional or different criminal history information for Mr. Lewis?
I have the exact same thing that council just gave.
Great. Well, I appreciate you being here. So you show the aggravated battery actually being a misdemeanor conviction?
Yes, Your Honor.
Okay. And what's the most recent arrest for Mr. Lewis?
There was a 2009 arrest for a probation violation.
And that was in Ohio or in Georgia?
That was here in Georgia. That's the only thing that I was showing here in Georgia.
Okay. Thank you so much. Appreciate you being here today.
No problem.
Ms. Primovic.
Thank you, Your Honor. This has been difficult for Mr. Lewis. I think you would figure out that your defense would be self-defense. Our facts would be, we would hope to project a little different, that Mr. Rowley was there jaw-jacking, trying to buy cigarettes, but that he left the home and came back in with a gun. And at that time, and the biggest issue here is the whole felony murder, possession of a firearm issue that we would have, which would be, you know, and when we talked to Mr. Lewis, that's what we boiled it down to. I think we'd have a really good self-defense claim, but the possession of a firearm. So we would expect, Your Honor, that Michonne Reynolds, that Mr. Abate already talked about, slid him the gun. And it
slid the gun to Mr. Lewis?
To Mr. Lewis.
Okay.
And that's when he used. So we had the conversation about how long did you possess it? How quick in time? What is the jury going to think about that? Yes, his record is very old, but thankfully, you know, he's grown up and he's moved on. So that's the issue with Mr. Lewis. Mr. Lewis also thinks that Mr. Riley was a gang member. The state, I had this conversation with Mr. Abate, and he says he doesn't think he was. My client does. He's concerned about going to prison and being threatened and having issues. He definitely was a bully, but we think he was also a gang member. So this has been very difficult for Mr. Lewis. He hates the fact that he was put in that situation. We've had that conversation. He said, you know, I was living my life. He had a bullet very near his spine. He can walk some, but it's better in a wheelchair because they don't really want him to have a walker here. And at the jail, he gets goes up and down the steps. Someone holds him, or he goes down on his rear end to go down the stairs. So he was just living his life. He stated that Mr. Riley lived on his sofa every now and then, but never paid rent, never formally lived there. So he was a bully. He thought he was a gang member. He was a jerk, and he wanted him out of his house. And so he had him removed. And then, as the state said, he came back and attacked him. and stole money from my client. We'd expect that to have come out. This is just an awful situation. It's tragic. And Mr. Lewis didn't want to be a part of that continuing tragedy with possibly getting a life without parole situation on the possession of a firearm by a convicted felon. He gets a disability judge. He was selling some cigarettes to make a little extra side money. No convictions in Georgia. He's been here approximately 18 years. He said he made some really dumb decisions as a youngster back in Ohio, but has grown up quite a bit. Because, Your Honor, of his medical conditions, because of his fear and risk of gangs. What do they call prison now down there?
Just where I'm at, Jackson. It just said Jackson was.
What do they call it?
Mob City.
Yeah, Mob City. They call Jackson Mob City, and he's very concerned, Your Honor. And we know this is, my client would ask for time served. We know this is extraordinary, and this is an extraordinary thing to ask for. But for the situation he's in, he's very fearful for his life. And I think we know from Fulton County Jail that that is a real thing, that we know from prison that it is a real thing. He can't at all protect himself, not one bit. He was already attacked and bit at Fulton County. There's records of that on Odyssey. So, Your Honor, we're asking for the time that he has served since June of 21st of 2022 be it, and that he gets his balance on probation. He really does want to go back to Ohio. I told him he would have to do the paperwork to transfer it back and get it done on his own, but he would really like to eventually go back to Ohio with all of his family and get out of Georgia and any potential issues that he may have with Mr. Riley and Mr. Riley's friends or gang members. And we appreciate the state for this offer and the reductions.
Sure, it certainly opened up opportunities for Mr. Lewis. I haven't heard of someone being bitten yet. I've heard stabbed, beaten, all that. The bite is new. Okay. Mr. Lewis, is there anything you want to add? You don't have to say anything at all, but this is an opportunity should you want to speak your piece. I heard what Mr. Abate had to say and what he thinks the evidence would show. Your lawyer has very clearly articulated a different perspective using the same players. But if there's anything you want to add, now is the time for you to add it.
First I want to say I'm sorry that this even occurred, this situation. I'm sorry for the family as well, what they're going through. I know, it's not easy for them. So I just wanted to really just to say, I fear for my life. And I know this guy was coming to do harm to me. He already has. And he was going to continue. And not one moment that it was offered to enter my home, even when he came to buy a cigarette. And the fear, I didn't even sell him the cigarettes. I gave him the cigarettes to get on my property. And it was always, get off my property. There's no reason to come here because of your intentions is always bad. So I just gave him that to get off my property. Just go. The whole situation was just go. Why are you here? There's no reason for you to be here. I'm just sorry for the incident. I wish it never happened.
Okay. That helps give me some direct context because of all the people here, you were the only one in the room when Mr. Riley was shot and killed. Mr. Lewis, I find there's a factual basis for your plea. I think the state has managed this well. I think that there is a sound legal defense, in terms of self-defense, I don't know that the jury will go with it, but it certainly is much more viable than what I hear in a lot of cases. And that's the risk you were facing, is maybe the jury doesn't go with it, because it's not black and white. And it sounds like maybe Mr. Stone and Mr. Reynolds had given slightly different version of events to different people. And one never knows which one the jury will credit. And if they credit enough of a story that shows that Mr. Riley was an aggressive person, but was an unarmed person, then you using deadly force might have been something that the jury would decide was unacceptable. And then you're looking at life without parole. And you're young. I mean, that's a long sentence. So I think this gives you a lot of light at the end of a relatively short tunnel. I appreciate that you remain afraid. I don't know if Mr. Riley was in a gang or not. It's a very flexible definition these days. It's hard to know what constitutes gang membership, but it sounds like you should have that fear if you're accurate, whether you're in custody or not. If you're a marked man, you're a marked man. And Ohio may not be far enough away. I hope that you're able to lead a relatively safe life as you move forward. Of course, there are consequences to what happened here. You took a life. Mr. Riley is someone's son, we know, and maybe a sibling and a friend to others, and he's none of that now. He's gone. I also find that your plea is knowing and voluntary. Knowing means you've understood what we've been talking about, and when you didn't, I watched you do it. You'd tug at Ms. Primovic and she'd explain it to you. Is there anything we've talked about that you feel you do not understand?
No.
Okay,
No.
good. I also find that your plea is voluntary, and that means that you've decided after lengthy consultations with Ms. Feely and Ms. Primovic and maybe other lawyers that moving forward with this non-negotiated plea to the reduced charge of voluntary manslaughter is in your best interest. I'm sentencing you pursuant to the Probation Options Management Act. All that means is that for the portion of your sentence that's on probation, as long as you're still here in Georgia, if you have a minor violation on probation, you and probation will sort that out. But if it's something more significant, you get arrested again for anything, that comes back to me. Ms. Primovic, may my staff sign the indictment on your behalf, indicating the guilty plea to the reduced charges?
Yes, Your Honor.
Mr. Abate, can we sign for you?
Yes, Your Honor.
Mr. Lewis, is it okay if we electronically put your name on the indictment indicating you've pled guilty to voluntary manslaughter and those other charges?
Yes.
Yes? Okay.
Yes.
Mr. Lewis, I'm going to sentence you, let me make sure I do this math correctly, on count one. Well, first, I believe count two should be vacated by operation of law. So there should be a sentence for count one, which was murder, is now voluntary. Count three, the state has dismissed. Count four merges into count one, which means I need to give you a sentence for count 1, 5, and 6. Your sentence on count 1 is 5 years to serve. Your sentence on count 6 is 5 years to serve to run concurrently with, at the same time with, count 1. Count 5 has to be 5 years, has to run consecutively to count 1. And that will be 5 years of probation. So it's a total sentence of 10 years to serve 5 years with a balance on probation. You will get credit for all the time you've been in custody because all that time in custody has been in relation to these charges. This is a parolable offense because the state has withdrawn its recidivist notice or not formally filed one. So you're eligible for parole. And I think this sentence strikes the right balance between recognizing that there was some justification for what you did and the gravity of what happened. Mr. Riley is dead and gone. And that's a tragic situation for the people who care about him. It's a significant situation in life anyway. And I know you didn't take it lightly. But based on the facts and circumstances I've heard, I think that is an adequate reflection of the seriousness of what happened, the nature of your criminal history. I appreciate and have factored in Ms. Primovic's observation that your Ohio convictions are from long ago. They're not from yesterday, and they're nonviolent offenses. But they certainly were offenses that disqualified you from having a gun. I understand what happened. I don't think it's the way it had to play out. And that's why, I guess, at heart, I'm not letting you go today. But I do think that a greatly reduced sentence from life is appropriate, given everything, including the candid remarks from Mr. Abate show me that this is the place where we ought to end. Mr. Abate, conditions of probation. One is that you stay away from Mr. Riley's family. I don't think you know them, but if someone says, hey, I'm Mr. Riley's uncle, you need to back off from them. Not that you'd even pursue them, but I just want to bake that in there. If you choose to go back to Ohio, you just need to make sure you arrange that through probation so that supervision gets transferred to Ohio. Okay? Mr. Abate, any other conditions in Mr. Lewis's sentence? Ms. Primovic, anything else?
No, Your Honor, thank you.
Mr. Lewis, I wish you the best when you get out. You will still be a young guy, and I hope you are able to surround yourself with a different group. Okay? Thank you. Thank you, Ms. Rivers.